I filed an IA for correction in the order by first by the lottery.
Yes. May I please, your lordship, with the
I am there for the petition.
No objection. How much time you want?
3 weeks, lordship.
Mr. S.S. Roy, audit CGC appearing for the respondents. Submits that he has received some instructions and therefore be granted 3 weeks time to file
What is it, sir?
affidavit. Since the prayer is made with the consent of the other side, same stands alone. List the matter accordingly.
Obliging. May I please, your lordship?
I beg to mention for listing of a matter for orders, your lordship. Any date next week, your lordship.
What order you want?
Lordship, this matter pertains to wrong fixation of pay scale, your lordship.
What is the order you want?
For orders, your lordship, in the order column,
That's right. It will be listed. Then you will
Lordship.
ask for order, is it not?
lordship.
What is the order you want?
Lordship, on last occasion, government, learned counsel for the government had took time for.
You
filing.
want the matter to be listed for orders.
Lordship,
So it will be listed for orders.
lordship.
Then the court will ask, what is the order you want? I'm asking you now, tell me what is the order you would want?
Lordship, affidavit in opposition, which the learned counsel for the government would file, we would give reply to that if they file in time, your lordship.
So they will file it. Once they file it, then only. the question-
Yes, your lordship, but the matter pertains to 2019, your lordship,
Hmm,
the year.
hmm.
And the petitioner already got retired, your lordship. And due to the such wrong fixation of pay scale, basic pay scale, your lordship, the pensionary benefit which the petitioner is getting is very low. Your
All right,
lordship.
when do you want it?
Any date next week, your lordship.
No, first week of June, put a date. First week of June.
First week of
Yes.
June.
Yes, non-miscellaneous, miscellaneous day, put a date.
Lordship.
May I please, your lordship, praying for listing of two contempt petition, lordship.
Hmm.
Next
Why?
week, lordship.
Why? Next week I will not allow any listing. But why you want it to be listed?
Lordship, what is for non-payment of DCRG amount, lordship?
Huh?
This DCRG amount has not been paid, lordship, that is why contempt has been made.
Fourth week of May, put your dates.
Lordship.
Fourth week of May.
What
Yes.
for, lordship?
May I please, your lordship? I beg to mention for listing, lordship.
Oh,
Already,
listing, you go to register. I'm not
Lordship.
getting into all this listing business.
already it is fixed in 15 February, lordship.
You make a request to the register with copy to her and we'll see if it is not done. This court has turned into a listing court. We are not going to do all these things.
May I please, your lordship? Lordship, with the consent, other side, I beg to, item number 32, my lord.
Hmm.
I need some instructions from my client, my lord. Item 32. And for the
You
petition,
have informed the other side.
my lord, MS V Sharma, my lord.
With the consent of learned counsel for the other side, Mr. M. Sahewal and learned counsel appearing for the petitioner submits that he be granted 4 weeks time to obtain updated instruction in the matter. Prayer allowed, list the case accordingly.
Deeply aware.
May it please your lordship, back to mention, these are three unlisted items, my lord, pertaining to read petitions. One read petition dates back to 2010. It is in the hearing stage. So may I pray before your lordship? to
It should
list
be
this
taken
matter?
today, second
And
half.
on 16, coming 16, that is on Tuesday, that is the hearing day. So if it is possible, may it be listed on 16.
Why it should be listed on 16 for hearing?
No.
There are other cases also fixed.
Yes, my lord, either on 16 or coming 23, on 23rd, that is also a hearing day. This, but one matter, which is relating to the, which is in
You
hearing.
said
stage.
unlisted matter.
Yes, my lord. These are unlisted, these are not in the daily list today, but
Oh, unlisted. That doesn't mean unlisted.
it's not in the daily list,
Hmm.
already been
You put dates as per your choice in the month of June.
in the month of June, my lord. And there are two other petitions also
All, whatever you have in the chamber.
in the
you
month of
give.
June.
Everything in June.
Obliged. Obliged.
May I please, your lordship? Lordship, in item number 51, lordship, as per direction of this court, we have filed an affidavit on 9th, lordship, that is yesterday,
Hmm.
that affidavit may be called for, lordship.
All right.
Obliged.
Lordship, I beg to mention for listing, Lordship.
Hmm.
It was posted last on 11/11/2022.
Yes, you go walk straight left and you'll see there's a joint registered bench.
Sorry,
You
Lordship.
can request, yes.
Lordship, I beg to mention item number 29. I have taken the consent from the other side, lordship.
Hmm.
Matter will be taken up after 2 weeks, lordship. My lord, I have no objection. My only prayer is that, my lord, if date could be fixed.
No, we'll take it up today. This adjournment and get a fixed date, that business is not, we can't do it anymore.
Then, my
Let
lord,
the matter be
his
called up.
prayer may be allowed then, my lord, because the affidavit will be required.
On the request of Mr. D. Chaudhary, learned counsel for the respondent number 2, made with the consent of the other side. This matter stands adjourned for 3 weeks. This case accordingly.
My lord, deeply appreciated.
May I please, lordship?
Lordship, I beg to mention item number 8, 9, and 20, Lordship.
Hmm.
My senior is not well, Lordship.
8, 9, and 20.
8, 9, and 20, Lordship. From Daily Leave.
You want adjournment?
Yes, Lordship.
As paid for by learned counsel for the petitioner, this matter stands adjourned for how much time?
After 1 week, Lordship.
For a week. Yes, same order. 8, 9, and 20.
Obliged, Lordship. My Lordship, I beg to mention for listing withdrawal tomorrow, my Lordship.
Tomorrow, why tomorrow? Day after tomorrow. Day after tomorrow. Yes,
I have similar prayer, Lordship, for withdrawal
day after
on
tomorrow.
12th, Lordship.
Day after tomorrow.
Deeply blessed.
Daily list for motion item 1, 2, and 3.
Lordship, in these matters, what had happened was there was a prior round of litigation. But the petitioners had put a selection process to challenge. Those petitions were disposed of with a direction to consider the cases of those petitioners for regularization or in the alternative for paying them the minimum scale of pay to give them a consideration. So there were 800 such petitioners. Some of them are the petitioners in Act number 1. So my instructions are that the cases of the petitioners in Act number 1, speaking orders will be passed within a period of 7 days, Your Lordship. But regarding Act numbers 2 and 3, though they are claiming for similar relief, Your Lordship, no such directions were passed in their favor. And those orders were specifically limited to the petitioners in those cases. So because of that, we have not been able to give them a consideration.
All right, then item 1 will segregate and post for motion after a week.
Yes,
And other cases will issue notice.
very well.
We take down in item 1. Heard Mr. B.D. Cole and senior counsel appearing for the petitioners. Also heard Mr. K.P. Pathak, learned standing counsel APDCL, as well as Ms. M.D. Bora, learned government advocate Assam, appearing for the official respondents. Mr. Pathak submits that since the petitioners in this case come within the purview of earlier order passed by this court, directing either regularization of their services or for payment of minimum pay scale.
I think consideration for regulation.
Purview of the earlier order passed by this court in connection with
WPC 1353/2020.
WPC 1353 of 2020, whereby an order has been issued to consider the case of the petitioners either for regularization in service or for payment of minimum pay scale. A speaking order will be passed in this matter within a week from today. Therefore, the matter will be posted for motion again after 2 weeks. Mr. Kaur has not objected to the same. In view of the above, this petition be segregated from the other matters and posted for motion again after 2 weeks. Item 2 and 3. you write-
Item number 1 may pay for a date on 18th of May, subject to your lordship.
The motion after 2 weeks, it will come.
Your lordship.
You calculate 2 weeks from today.
Then 25th of May.
Yeah, that is when it will come. Motion after 2 weeks means exactly after 2 weeks it will come. In the other matters, you write, Ekeleve Dibudute, I heard Mr. B.D. Cole and senior counsel assisted by.
Oh, I don't appear.
Actually, you are not there.
I mean,
Heard Mr. So-and-so like counsel.
this matter is similar, my lord, already
You,
discussed of some.
you have, you are appearing in both the writ petitions,
Yes, your
2
lordship.
and 3.
2 and 3.
So they are contesting your case. It cannot be disposed of.
No, if the petitioner is willing for a direction in those terms, then it can be disposed of. Exactly in those terms for consideration.
My lord.
It's up to them, your lordship.
All right, then what to do? You pass a speaking order.
Yes, we'll pass a speaking order. Exactly, the order is there in Act number 1, your lordship. If the same order is passed, we'll consider the cases and pass a speaking order.
Then why segregate? The segregation part to continue.
Because unless that order is passed, because the earlier order was limited to the petitioners, these two matters can be disposed of today.
Segregation in Indigo, 2 and 3 live of so-and-so for the petitioner. Also had so-and-so, 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 Divo, privacy debate. Mr. Pathak submits that since no order from the courts, since there is no earlier order from the court to consider the case of the petitioners either for regularization or for payment of minimum pay scale, their cases are still pending. First up. Mr. Pathak has, however, not denied that the cases of similarly situated employees are now being considered in the light of orders passed by the court in WPC number
1353 of 2020 and connected petitions.
and 1353 of 2020 and connected petition. First up, if that be so, the cases of the present petitioners be also considered and appropriate order be passed therein. Let these matters be listed, let these matters be listed again after 2 weeks.
Very good.
Along with item 1.
Obligation.
Kindly oblige your lordship.
Your lordship.
What is the matter?
My pleasure, Lordship. Last occasion, PNRD is to sell take instruction is matter. It is last order dated 19 January, Lordship. And there's to apply to court.
Yes, what is your instruction?
Lordship, we are waiting for the instruction, but Lordship. mm, in
No, you either submit or don't submit. Because after your submission, I may dispose of the matter. Don't say that this much today and something some other day. That will not work out in court proceeding.
Lordship, what
Are you
text
prepared to make your submission or not? There is the order of 19/1/2023.
Yes.
And then why this matter should be kept for motion? We'll dispose it of in admission. If they don't get instruction, we'll pass a order in your favor.
Because they want to take instructions, so I think I am not, it is not.
What is your prayer?
My prayer is, Lordship, I had problem in that I waited for more than 18 years, Lordship. And regarding annexure 5 and 6, it gives me that, gives me belief that I'll be getting appointment. And regarding that, my prayer is that in page 13 of this petition, should accommodate the petitioner then in PNRD or to allow the petitioner to continue as a fishery technical consultant in the age of superannuation. This is my prayer, Lordship. This is the main prayer. So, Lordship, case is
Your
that,
client was appointed on under 3F.
sorry, Lordship, yes, temporary appointment under regulation of 3F appointee, Lordship. So what happened? After 4 months, I was terminated, and then because I have to make a room for the new selected candidates, then I was being apprised that I'll be getting a job when the vacancy arises. And Honorable Lordship Gogoi.
Sorry, what happened? You will get a job.
Yeah, no, I will be getting when I will be called for accommodation when my name will be in my turn. When my name.
It cannot be done.
No, Lordship. My humble submission is that I was in the waiting list, Lordship. So, Lordship.
Which
then-
waiting list? Let me
Lordship.
see. Which is the waiting
Lordship.
list?
No.
Page number?
Page number, Lordship, as per selection list, 19-1 annexure. Annexure 1, Lordship. Page 18, Lordship. My serial number, page 18, Lordship. Is a type copy, Lordship.
Yes, so this is 6th of January 1998.
Yes, Lordship.
Yes. Was your client appointed pursuant to this
No,
list?
no.
Then this list is valid for how long?
So list, problem is that.
Not problem. I'm asking you, this list is valid for how long?
List is, there is no fixed order. They gave me reply the validity of the merit list for 1 year.
Mr. Mahanto,
1 year. But I was being not informed, Lordship. I was being apprised that when the vacancy arises, my name will be called for, Lordship.
who apprised you?
Annexer 5 and Annexer 6, Lordship, 5 and Annex 6, Lordship. Because they are following, they are following honorable Lordship order, Lordship. Annexer 5, Lordship, page 40, Lordship, last part, Lordship, page 40, last part. Subject to the available vacant post of extension officer fishery in the department compliance of honorable High Court order dated 10/9/2003 in WBC number 4910/2000, Lordship.
All right, take down hard, Mr. G Das. Mr. Das,
Mr. G. Das.
you don't have any case, but I'm issuing notice. This who said what and who writes what doesn't matter. The question is whether you have a right under the law. And that right can only be enforced.
Lordship, my humble submission is
Whatever
I
your
am a unemployed, so I am working in
Correct. So
as a
you want
contractual
appointment on the basis of a select list prepared in 1998.
Lordship. Lordship, thing is that actually, what happened? I was been thinking that I was as a layman, Lordship. I do not know whatever consequence would happen, Lordship. So actually,
That's right, that's right.
actually, Lordship. so
Not
Lordship-
knowing the law is a very, very good defense.
Lordship,
It is acceptable in law, is it? Anybody can do anything and say that I didn't know the law.
no, Lordship, my submission is not that. My submission is that now I'm working under a contractual post in fishery as a under World Bank project, Lordship, and that will be and on next year, 2024. And Annexer 11,
Mr. Das, I'm asking you a simple question. I
Lordship.
hope you understand.
Lordship,
Court's time is precious.
Lordship.
I am asking you, are you seeking a permanent appointment in the post of fishery extension officer
Lordship,
on the basis of your client's name included in the waiting list
Lordship,
published in the year 1998 or not?
Lordship.
You want this court to pass a mandamus that appoint him as per the select list of 1998. That's your case in a nutshell?
Lordship.
Huh? You believe that order is permissible?
No, another prayer I have, another prayer.
All right, all right.
Another prayer I have, Lord.
Last
Another prayer, Lordship. I was also,
made in the writ petition. Ms. N. Bora Lanet, Standing Council, PNID Assam submits that in terms of the order dated 19/1/2023 instructions as called for are still awaited. Mr. T.J. Mohanto, Lanet Senior Counsel listed by Ms. B. Bora. P. Sharma is present on behalf of the APSC and Ms. M.D. Bora, Lanet Government Advocate on behalf of the state. Having regard to the controversy involved in this writ petition, this matter would require further examination of such issue motion returnable in 6 weeks. Since Ms. Bora has appeared and accepted notice on behalf of
1, 2, and 4.
for numbers 1, 2, and
4.
4. Ms. M.D. Bora for respond number 3 and Ms. P. Sharma for respond number 4. Respond number 5, service of notice is deemed to be complete in this case. Extra copy of the writ petition be furnished to the Learned Department Council so as to enable them to obtain instruction. Yes.
Master Bless.
May I please, Your Lordship? A matter relates to compassionate appointment, Your Lordship. Last occasion, Your Lordship has sought.
Lordship, the instruction yet to be received, Lordship.
It is already mentioned in the office memorandum dated 1/6/2015, Your Lordship. Kindly peruse page 33A, Your Lordship. 33A, last clause number 2, Your Lordship. Clause number 2, may I read, Your Lordship?
Yes.
Dependent family member means a person who was wholly dependent on the government servant at the time of his death in harness, or retirement on medical grounds, or missing, as the case may be. Here, the petitioner's father retired on medical grounds, Your Lordship, because he sustained injuries while
Father retired when?
retired on Your Lordship.
36, 2009, Lordship.
By total date 36/2009, Your Lordship.
So you want this matter to be disposed of at the motion stage?
No, Your Lordship. I'm praying for issuance of notice at this stage, Your Lordship.
Heard Mr. K. Miral and counsel for the petitioner. The writ petitioner herein is aggrieved by rejection of his application for appointment on compassionate grounds. Mr. Mira submits that the case of his client is covered under para 2 of the notification dated 1/6/2015, bearing number ABP 50/2006 PT 182, page 33 at the same, issued by the Government of Assam, Department of Personnel bracket B. Mr. J.K. Goswami, learned
All the respondents.
additional senior government advocate Assam, appearing for the respondent, submits that instructions as called for are still awaited, and therefore some more time be granted. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Goswami has appeared and accepted notice on all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the learned department council.
Obliged.
To enable him to estimate.
Please, your lordship, lordship may kindly take minute after some time. He's in Lexington, another book.
Lordship, the
Okay.
copy of the petition has not been served to us, Lordship, although our name has been reflected, Lordship. Standing Council Water Resource.
What is this matter about? What is this?
Compassionate.
Compassionate? You serve a copy and we'll have it next week. Mr. R. M. Das, learned counsel for the water, standing counsel for the Water Resources Department, submits that your matter submits that no copy of the writ petition has been served upon him. Mr. Since the relief prayed for is against the Water Resources Department, a copy would have to be furnished to the department, learned department council. Mr. A. M. Babuya, learned counsel for the petitioner, undertakes to furnish a copy to the learned counsel for the Water Resources Department during the course of the day. Registry to therefore list this matter again for motion in the next week.
Item 7.
My lord, this matter relates to selection of Gaon Pradhan, my lord. Your lordship may kindly see the notice at page 13, my lord, annexure A. Pursuant to this notice, the petitioner also, my lord, submitted his application and appeared in the interview, my lord, along with others, but the result was by the select list was not
File
declared.
appeal, file appeal, that's all.
My,
File appeal. There is a provision of appeal 162C. To file it.
my lord, he has filed representations.
No, representation will not do.
That may be
You are withdrawing
before
this
the-
writ petition with liberty to prefer an appeal under 162C. That is the order I am passing. Ms. S. B. Chaudhary, learned counsel appearing for the petitioner, seeks leave of this court to withdraw this writ petition with liberty to prefer an appeal under Rule 162 bracket C bracket close of the executive instructions framed under the Assam Land and Revenue Regulation, 1886, before the Lower Assam Divisional Commissioner.
Central.
Central Assam Divisional Commissioner, assailing the selection of the respondent number.
9, my lord.
Who is the respondent number 1?
Private respondent, he has been selected, not 9, my lord, 5.
Respondent number 5 for appointment as Gaon Pradhan in respect of 11 number Simolaguri / Nij Fatah
Not yet appointed, selected, my lord.
1-2 Utaka Famila Ali Gaon under Raha constituency of Kamalpur Circle in the district of Nagaon. Mr. J.K. Goswami, learned government advocate Assam, and Mr. S. Bhattal, understanding council revenue department Assam, are present and do not have any objection with the prayer made by the petitioner's council is allowed. The petition stands disposed.
Stand, your lordship, it may stand closed, my lord.
Yes.
Read petition may
Yes,
stand
yes.
closed.
Item 10.
May it please your lordship.
You already retired.
Yes, your lordship.
You want promotion now.
Yes, your lordship, because they have not considered my case, your lordship. I had a right. to
But
be
why didn't
considered.
you come when you are in service?
I was expecting that they will consider my case, your lordship. But they didn't consider, and that is why. I
When did
filed
he
appeal
retire?
petition, your lordship.
When did your client retire from service?
He retired on 31/12/2000. Oh, sorry. 22. 22. 39/22, your lordship. 39/22.
What is there in this petition now?
At least my case will be considered,
Cannot
your
be-
lordship.
cannot
in this
be.
case.
Retired employee, show me a judgment. I'm issuing rule.
Yes, your lordship.
Yes. Had Mr. T. Devi, learned counsel for the petitioner, the read petitioner has retired as superintendent engineer bracket mechanical in the department of in the irrigation department on attaining the age of superannuation with effect from 30/9/2022. Petitioner is aggrieved by failure on the part of the respondents to prepare the gradation list and also to consider his case for promotion. Hence this petition. Mr. N. Upadhyay, learned standing counsel irrigation department Assam, and Miss Yafo
Respondent number 7, accountant general.
and Miss So-and-so, learned counsel appearing for the respondent number 7 have prayed for some time to obtain instruction in matter. Issue rule returnable in 8 weeks since Mr. Upadhyay has appeared and accepted.
1, 2, and 3.
Respondents numbers 1, 2, and 3. Mr. R.C. Botpujari for respond number 5. Ms. P. Sharma for Ms. S. Borwa for respond number 6 and Ms. So-and-so for respond number 7. Service of notice on the state respondents is deemed to be complete. In this matter, extra copy of the petition be furnished to the learned department council. A petitioner to take steps for service of notice upon the remaining respondents.
I'm deeply obliged, your lordship.
Item 11.
May
it please your lordship. My lord, regarding the appointment of the Ganguradan Major. So what happened, my lord, in this case, my lord? Our case is that, my lord, deputy commissioner appointed, my lord, selected and appointed. So executive instruction is not clear. Our grievance advertisement, my lord, page 20, my lord.
What has happened?
My lord.
What is your case?
My lord, case is that, my lord, my father, my grandfather, my elder brother, my great grandfather or Gangura, my lord. And in this advertisement, my lord, in column number 5, my lord, there is preference given to the family of the Gangura. That was not given, my lord.
Prefer appeal.
My lord, and that is why, my lord, when the appeal is the sub-divisional officer Sodor, then it will be deputy commissioner. Now, in this, my lord, case, my lord, the deputy commissioner selected and appointed, my lord.
No, appeal to be
Commissioner.
filed before divisional commission.
Commissioner.
My
Yes,
lord, that is in the executive instruction, that is not clear whom to assign, my lord. This is the problem.
No, we are
166.
passing orders. Divisional
Yes, my lord.
commissioner is the authority to hear appeal. This is Morigaon, it will be Central Assam Divisional Commissioner.
Yes, my lord.
In the-
It is cleared, my lord, 166.
So he has not read it.
Divisional commissioner, 60 days.
Against deputy commissioner.
No. Divisional.
No, against the order of the deputy
Only
commissioner.
Commissioner, Principal Executive Council, shall be lied to the divisional commissioner within a period of 60 days.
Withdraw and file an appeal.
My lord.
Yes. Mr. M. Hussain, Learned Counsel for the petitioner, same. Respond number 5. Yeah, what is actually withdraw? Ms. MD Bora, Mrs. Doctor.
I am for 2, 3 and 4, my lord.
MD Bora for 2, S. Doctor for SC revenue for 1, and MD Bora so and so are present. And do not have any objection if the prayer is allowed.
Only one submission to be reported that.
No, you should, if you would have filed the appeal, then I would have passed on all that. You first file an appeal.
My lord, same as my lord, item number.
My lord, I am for 5 also.
Acha. 1 to the S. Doctor, SC revenue, ROP.
Item number 21.
You are for 5 also.
My lord.
Then who is the private respondent here?
No, my lord, first page, private, 6.
6. Nobody is opposing motion, madam.
Motion matter, private.
Assailing the appointment to respond number 6. Appointment no, selection of respond number 6 for appointment in the post of Gaon Pradhan is also on the ground stated in the writ petition. Buji paisa na order to withdraw. Item 21 also.
21.
All right. There, who is the private respondent, Sahil Hussain?
6 private, same my lord.
Same.
This will be all Lower Assam Central Divisional Commissioner,
Commissioner,
Central
my
Assam.
lord. Central Assam Division Commission.
Yes.
Obliged, madam.
May please, your lordship. So in this case, lordship, I've been appointed as a Sahayak and office cum field assistant in the year 2013, your lordship. So I have completed 10 years of service. Now my only limited period is, lordship, as per the direction in order dated 23/2/2021, 29/3/2023, lordship. Same direction may be given, lordship.
Which page?
Lordship, it is in page number 35, the effective portion. Lordship. This is the earlier order, lordship.
These petitioners, your lordship, are similarly placed as the petitioners in act numbers 2 and 3, your lordship.
I can, page 35.
So should we fix it along with the?
If the same directions are passed, we will consider their cases also.
Acha. Heard Mr.
TJ Das.
Ajay Das, Land Counsel for the petitioner, who submits that the case of his clients are covered by the order dated 29/3/2023 passed by this court in WPC number 1556/2023, and therefore their cases be directed to be considered accordingly. Full stop. Mr. K. P. Pathak, Land Standing Council, APDCL, 2 weeks time to obtain instruction in the matter and appraise this court. Full stop. In view of the above, let these matters be listed again with item numbers 1, 2, and 3. Case number Didibo. It is made clear that if the petitioners are also found to be, if the petitioner is also found to be similarly situated as the writ petitioner in WPC number so and so, then his case be also considered either for regularization in service or for payment of minimum pay scale. And the speaking order be passed in respect thereof.
Much obliged.
My lord, actually, this matter is covered by judgment dated, my lord. 3/11/22 at page 59. But today, I think they would like to have the instruction. At page 69 is the operative portion, my lord. 68 rather. Bottom para 20. From a conjoined reading of the provisions of the revised pay rule of 2017, more particularly rule 1, 2, 4, 32, etc. Together, this court is of the unhesitant view that petitioner was in service on 31/3/16 and who retired from service on reaching the age of superannuation also on 31/3/16 cannot be categorized and bracketed in the category of existing pensioner on 31/3/16 as he acquired the status of pensioner only on and from 1/4/2016. In such view of the matter, benefits under revised pay rule of so-and-so cannot be worked out by resorting to rule 31.
Mr. Pathak, are you appearing in this case?
Yes.
Assam Electricity Grid Corporation?
Yes.
On electric grid, I don't accept. I only appear for power distribution.
For they do not have a standing counsel.
No, Mr. S. Kotoki is perhaps standing counsel.
So,
Mr. Kotak, are you there in this case?
I'm not getting any copy from them.
Acha, are you standing counsel for Assam Electricity Grid Corporation Limited?
We haven't given copy,
Alright,
my lord,
then
because
let it
we are
be
under
next-
the impression there is no.
All right.
Okay,
Let it
to
be
the survey
listed
copy.
next week and
My
in
lord,
the meantime.
my lord, just now we can give a copy, my lord.
All right, Mr. Ken Chaudhary, senior counsel, is appeared for the writ petitioner. Mr. S. Kotoki, learned standing counsel, Assam Electricity Grid Corporation Limited, submits that neither his name is shown in the cause list, nor any copy has been served upon him. In view of the above, let this matter be listed again on next Wednesday, give the date. By reflecting the name of Mr. S. Kotoki, learned counsel for the respondent in the cause list. Since Mr. Chaudhary has made a submission that the case of his client is covered under the judgment and order dated 3/11/2022, passed in WPC number 1607/2020, 2020. The learned standing counsel may obtain requisite instruction facilitating disposal of the writ petition at this stage of motion here.
Well, I'm just informing my learned friend, another similar matter has come up in court number 17. So I'll give a copy there also, my lord. একটু নেয় আমি। আমি একত যাও।
Lordship, Lordship, there's a departmental proceeding, Lordship. Departmental proceeding is going on against the petitioner, Lordship, and without furnishing the relevant document, Lordship, as well as Lordship, the summon to appear before the inquiry officer was received after due date fixed for appearance, Lordship. This, therefore, Lordship, seeking the direction from this honorable court that to furnish the the relevant documents as well as the reschedule of the dates for appearance.
Which documents have not been furnished?
Yes, Lordship.
Where is the pleading?
Yes, Lordship. Annexure, Lordship. Yes. 16, Lordship. This letter dated 17/5/2023, Lordship.
Where is the pleading in your writ petition, Lordship? Where is the pleading in your writ petition?
Yes, Lordship.
Yes, which paragraph?
Yes,
Give
Lordship.
me the paragraph number.
Yes, Lordship. Lordship, in my paragraph, Lordship, paragraphs 18, Lordship, paragraphs 18, it is a category
Which
stated,
documents have not been furnished to you in the inquiry proceeding?
Lordship.
Where is the pleading?
Annexure 19 and
No, if
A
there is
and
no
B.
pleading, then you have to withdraw
Yes.
and come afresh. Without pleading, all right, I'll issue notice, but I will not grant any stay order. Your grievance is that some documents has not been given to
Lordship,
me.
Lordship.
You don't state it in your writ petition.
I had already sent a letter, Lordship, and impugn letter is the letter.
So we'll
dated
issue notice, that's all.
17/5/2023, Lordship.
You want a notice?
No, Lordship, the case may be disposed of, Lordship, direction to the.
There is no statement.
Lordship, in my statement, I categorically stated that the documents which is sought by me on 17/4/2023, Lordship.
Which is the document?
Yes. Kindly see the annexure 19, Lordship.
Actually, there is no statement about the document.
Regarding the document, Lordship, I had stated that on 17/4/2023, the 17/4/2023, Lordship, I submitted a letter to the authority that to furnish me the following documents, Lordship. These are all the documents is listed, Lordship, in annexure 19B, Lordship.
Annexure?
19B, Lordship. All the documents are listed, Lordship.
Mr. J.K. Goswami, learned counsel for the petitioner, submits that although a disciplinary proceeding is now under progress against his client, yet none of the documents sought for before the inquiry officer has been furnished to him, as a result of which the interest of as a result of which the procedural safeguard available to the petitioner has been denied in this case, thus vitiating the inquiry proceeding. You are appearing for whom?
I'm proxy appearing for the bank, my lords.
You are proxy.
Yes.
Who is the main face?
I'm.
Whom are you proxying for?
D Banerjee.
D. Banerjee.
Standing counsel for Assam Gramin
He
Vikas
is
Bank.
not come to court today.
He is ill, my lords.
He is ill.
He's ill. So I'm stepping into his shoes for
All
today.
right. But
My lords,
Yes.
on the issue of grant of stay, a notice may be issued. I have no difficulty because I also have incomplete instructions from my client. I got it yesterday evening itself.
no, we'll have it next week. You complete your instruction and tell us whether these documents in
My lords,
annexure.
I'm only on the, I beg to interject. I'm only on the limited issue of stay. So stay should not be granted.
That you can't say whether it should be or should not be. We'll decide that.
because
But you tell us whether these documents has been given to the petitioner or not.
asking for CCTV footage, my lords.
Yes, I'm giving you 1 week's time to do that. We'll post it on motion. Yes, Mr. Your name, please?
D Banerjee.
You are also D Banerjee. Mr. D Banerjee, learned counsel appearing on behalf of Mr. What is the
D.
name?
Banerjee.
Full name of other D Banerjee?
Debabrata Banerjee.
Debabrata Banerjee submits that he be given a week's time to complete his instruction on the basic grievance expressed in the writ petition. In view of the above, let this writ petition be posted for motion again on next Wednesday, given date, 17/5/2023, so as to enable the learned counsel for the respondents to obtain instruction and appraise this court as to whether the documents sought by the petitioner White, letter dated 17/4/2023, bracket annexure 19B, bracket close, were furnished to him, and if not, the reason thereof. One extra copy of the writ petition.
Till that, Lords,
No, you wait, this motion matter, no
Yes.
till date. We'll quash it.
coercive action.
We'll quash it if they don't, depending on what instruction.
My lords, I may be permitted to file an affidavit
You do whatever you want.
1
but
week's time.
Either you convince us that these documents were given or not given for right reason,
My
or
lords,
we'll
he is
interject with the proceeding on the next day.
charged
No further
under
time.
regulation 43.
That's
of-
not the point. Point
Uh,
is, if you're conducting an inquiry, you have to give him the documents.
All right, I'll seek instructions. Much obliged.
You can do it on your own if you want.
All right.
You can do it. If
Right.
you give a submission that you will go back to that stage, give him the documents, we'll close the matter. Otherwise, we'll stay and examine it. That's it.
My lords.
Well, the petitioners here are contractual worker under the APDCL, my lord. Some of whom.
Mr. Banerjee, what is your name, full name?
Debayan Banerjee.
So Debayan Banerjee appearing for Debabrata Banerjee.
May I please? The petitioners here, my lord, are contractual workers under the APDCL. Some of whom have been working for about 27 years. So these petitioners and some others together came before this honorable court seeking regularization of their services or a minimum pay scale. So the petition was allowed. Your lordship will find the operative part of the judgment at page 127. Paragraph 10.
Same matter.
No, in their cases, the speaking order has already been passed.
Yes, ma'am. There is a speaking order.
Speaking order is at page
Page
number
number?
146.
146. Our claim. is
Claim has
based-
been rejected.
Yes, claim has been rejected.
Then we have to hear it. We
My
need to
lord.
notice card, Mr. O. Lashkar Learned Counsel for the petition. Assigning the speaking order dated 21/3/2023, by means of which the prayer made by the petitioners for regularization of their services have been rejected. The instant writ petition has been filed. I peruse the statements, averments made in the writ petition, and also consider the submission of petitioner's counsel. Mr. KP Pathak, learned SC APDTL, prays for some time to obtain instruction in final. NOM 8 weeks since Mr. Pathak.
I'm
is
referring for
here.
question numbers 2 to 5, your lordship.
Okay, then Ms. S. Borwan, and the government advocate Assam has appeared for respond number 1 and Mr. Pathak for respond numbers 2 to 5. Service is complete in this case, extra copy of the writ petition is furnished to the learning department.
Obliged.
If you are having them to obtain instruction. 5 of zero.
May I please, Your Lordship?
Yes.
Well, Lordship, here the petitioners are the candidates appear before the examination conducted by the respondent authorities to fill up some certain post of fourth grade under the all departments under the government of Assam, my lord. Here, my lord, the respondent authorities has published an advertisement on 25/3/2022, Lordship. Lordship will find that advertisement at page 18, my lord, annexure 1, my lord. There, my lord, the two category of the post, my lord. One post is minimum qualification up to class 8. And another is the minimum qualification SSLC, and the maximum qualification is higher secondary, my lord, is SSLC, my lord. There, my lord, kindly peruse, my lord, at page 18, my lord. The maximum eligibility qualification for all class 4 posts shall be SSLC class 12 or equivalent examination pass, and those who have educational qualification higher than this maximum eligibility educational qualification on the date of application shall
What
not
is the
be.
maximum qualification?
Lordship,
What was the maximum educational qualification?
that is higher secondary.
They have allowed graduates to participate.
Yes, Lordship. And my lord, in this interestingly, my lord.
You tell us, we'll post it after 2 weeks for
Yes,
motion.
Lordship.
Give him 2 extra copies.
Yes.
Mr. D. Bora,
My
Learned
lord,
Council.
here, my lord, one thing, my lord, they are going to appoint those persons, my lord, without publishing the any result sheet, my lord. Only individual result sheet has been given to the individual candidate through a portal, my lord. Till the no application result sheet has been published. Tomorrow they are going to make the appointment, my lord.
No stay order.
No, my lord. In the meantime, my lord, some because there is a huge amount of posts, my lord. In the meantime, my lord, some subject to the outcome of this petition, maybe.
Mr. D. Bora, Learned Council for the petitioner submits that although the maximum educational qualification was fixed at as 10+2,
10+2.
yet candidates who had completed their graduations have not only been allowed to participate in the selection process, but are also in the process of being appointed. According to Mr. Bora, said, sorry, Mr. Borua, the said measure is in clear violation. According to Mr. Borua, such a recourse is in clear violation of the terms and conditions of the advertisement notice. Full stop. It is also the submission of Mr. Borua that the authorities are yet to publish the final results.
Yes.
Notwithstanding, full stop, notwithstanding the same, there is possibility that appointment orders would be issued in near future. Mr. J. K.
Tomorrow,
Goswami, please for
No, Lordship, not tomorrow, Lordship, and on 26th it was postponed. Lordship.
Mr. J. K. Goswami, Learned Additional Senior Government Advocate Assam, prays for time till 26/5/2020. No, you will get time till 19
Lordship.
19 May 2023 to obtain instruction on the above points and appraise this court. 2 extra copies of the petition be furnished to Mr. Wasabi during the course of the day. Let him first get the instruction, then we'll see.
Obliged.
Item 17.
My lord, in this case, my lord, the petitioner, my lord, was appointed, my lord, my lord, assistant commandant, my lord, in the year, my lord, the 2002, my lord. First into the, my lord, all India merit list, my lord, where, my lord, the petitioner's position was, my lord, 88, my lord. And my lord, after
So
selected,
what are you challenging here?
my lord, my lord, what happened, my lord, the draft seniority
What
list,
happened will come later. What are you challenging here?
my lord, the private respondent, my lord, 7 to 10, my lord.
What are you challenging here?
My lord, challenge, my lord, the draft seniority list, my lord. is
Say
Annex
that.
14. Annex
I had to ask you 4 questions to get this answer. Where is the draft selection?
Yes,
Selection
lordship,
list?
that is the Annex 14, lordship.
Hmm.
Annex 14 and list is the Annex 5, page 50. Page 54. And petitioner's number is my lord, page 57, the last my lord. the serial number is 193, my lord. Where, my lord, the in original merit list, my lord, the private
Page number,
page number 57, my lord. Petitioner serial number is 193, my lord.
Yes.
My lord, the original merit list, my lord, petitioner's position was, my lord, the 88th, all India ranking, my lord. And my lord, the private respondent, my lord, 7 to 10, my lord. They are the, my lord, below the petitioner's position, my lord, in all India merit list, my lord. And my lord, the respondent number, private respondent number 10, 11, and 12, my lord. They are, my lord, not in the, my lord, original merit list, my lord.
But this select list was published in 2020.
20, my lord. My lord, now, my lord, all are, my lord, the similar, my lord, post, at present, my lord, they're holding, my lord, they're similar post, my lord, they commanded, my lord. Next, my lord, if, my lord, they are, tomorrow, my lord, the next promoted, my lord, then, my lord, it, the private restaurant, my lord, my get benefit, my lord.
This is seniority draft, seniority list of assistant commandants.
Assistant commandant, ma'am.
Assistant commandants in which force?
My lord,
SSB.
SSB, my lord. Sasastra Singh, my lord.
And it was published when?
Is a 3/8/2020, my lord. 3rd August 2020.
Take down. We'll issue notice then.
Lordship.
Mr. Ellen Dihinga, Learned Counsel for the petitioner. The lead petitioner herein claims to be serving as assistant commandant under the Seema Suraksha Ball, bracket SSB. Assailing the draft revised seniority list of assistant commandants, bracket GD, bracket close, notified by OM dated 3/8/2020. The instant writ petition has been filed inter alia contending that persons junior to the petitioner has been placed above him in the draft seniority list. Full stop. Mr. Dihinga submits that if the seniority list is given effect to for further promotion, then the same would cause serious prejudice to the interest of his client. Full stop. Mr. K. Gogoi, learned CGC, appearing to the respondents.
1 to 6, Lordship.
1 to 6 prays for time to obtain instruction in the matter. Prayer allowed. NOM 6 weeks. Since Mr. Gogoi has accepted notice for respondent numbers 1 to 6, no formal 8 weeks. No formal notice is required to be sent to the said respondents in this case. Extra copies of the writ petition be furnished to the Learned Department Council. Petitioner to take steps for service of notice upon respondent number 7 to 13 by registered post. Yes.
My lord, it is regarding the, my lord, temporary chokidar of the IB, my lord, which is in the Dhuri district, when it's Satrosal. It is at Satrosal, my lord. What happened, my lord, is the earlier chokidar died in the year 2010, and after the death of the 2000 earlier chokidar, my lord, the tourist officers, those who are comes to visit, my lord, and Satrosal,
How this kind of prayers can be made?
my lord.
How can the court direct that he should be given temporary appointment?
At least, my lord, whatever, my lord, I am my lord, working as,
You withdraw, otherwise I'll have to dismiss it.
my lord, I am working about after 2010, my lord, whatever. Subsequently, I applied for the direct recruitment. I want only preferential. Times and again, I filed petition before the authority, my lord, but the authority direct asked me to file application whenever the advertise is made, my lord. So, my lord, I applied for the post, my lord. So,
This prayer cannot be entertained. in a writ
Only
petition.
I have, we are in the selection and
You complete your argument, then I'll pass the order. It cannot be done.
only.
Only or not only, this order cannot be.
Preference, I record only preference given in the, at the time of the selection and appointment, that is my.
That you apply?
Well,
when-
already I have applied, my lord, and already I have applied.
Applied when?
My
Yeah,
lord,
show me the advertisement.
my lord, as per our 18, my lord, I was applied through online, my lord, and it is not given properly, my lord. Para 18, my lord.
Online, there was an advertisement.
There is a.
Where is the advertisement?
That copy is not there.
Then it will not be possible. Then it will not be possible.
Only, my lord, lordship may issue notice and. Yeah, subsequently, my lord.
These are matters councils few months, few years back would never file. But today people are filing anything. Anything and everything.
That's why.
Catch hold of someone and file a case. And let the court, and some judges will pass some orders like this, some judges, they are taking the chance. What you want to do, you also want to take a chance to do it.
No,
But as per legal principle, these cases don't lie.
yes, Lordship, it doesn't.
Earlier, there was a filtration. There is to be responsible counsels who will never file something like that. Today, everything has, gone where.
And Lordship, the claim by the petitioner
Right.
that.
Had
Uh,
Mr. M. Hussain, learned counsel for the petitioner, also had Mr. B. Chaudhary, learned you are appearing for?
PWD, Lordship, all
Understand.
are responded.
PWD appearing for the respondent number 1, 2, and 3. The read petitioner herein claims to be serving as a chowkidar in the in the
Satrasala, I mean.
inspection bungalow of PWD situated at Satrasala in the district of Dhubri since the time of death of the permanent chowkidar, who died on 8/4/2010. Full stop. The petitioner has approached this court filing this writ petition, seeking a direction upon the authorities to appoint him as chowkidar in the inspection bungalow on temporary basis till such time regular process of appointment of a chowkidar in the Satrasal IB is made by the respondents. Full stop. On perusal of the materials available on record, there is nothing to show as to on what basis the petitioner has been asked to perform the duties of chowkidar in Satrasal IB. So therefore, his claim that he is discharging the duties of chowkidar Satrasal IB cannot be accepted based on materials and record. First of, insofar as the other prayer for appointment on temporary basis is concerned, in the absence of a regular process of selection, no writ of mandamus can be issued to appoint a petitioner on temporary basis in a post, full stop. In a post, since such a writ would not lie in the realm of service jurisprudence, full stop. If the respondents wants to make any temporary appointment in exigencies of public service, it is a matter entirely open to them. But the High Court cannot issue a direction to make such an arrangement, since the same would purely lie in the domain of the respondents, full stop. However, as and when a regular selection process is initiated, the petitioner would be entitled to participate in the said process if he meets the eligibility requirement. Therefore, without expressing any further opinion in the matter, this writ petition is disposed of by leaving the respondents at liberty to take appropriate step in the matter.
Lordship, that last portion as and when, Lordship, because now under the new act of Commission for Grade 3 and 4, they have to apply, Lordship. To
As and when regular processes, leaving the matter open to the authorities to take appropriate action in the matter.
Highly obliged.
Item 19.
May I please, your lordship? Lordship, we have a award in our favor. Since 2017, we have been fighting for execution of the award, lordship. So we are praying for a direction to be issued to the respondent number 2 for a early disposal of the Bakijai case, lordship.
Early disposal of Bakijai case.
Bakijai case.
Bakijai case is pending where?
Before the Deputy Commissioner Tinsukia, lordship.
We have to issue
2018.
notice. We have to issue notice to the,
Please.
your name, please.
A Kakuti.
Mr. A. Kakuti, learned counsel for the petitioner. The instant writ petition has been filed, being aggrieved by the delay in disposal of Bakijai case number PINSE. We'll get it in page 12. So and so, pending before the assistant. It is pending before whom?
Before the Deputy Commissioner Tinsukia and recovery officer.
Before the deputy commissioner come recovery officer Tinsukia, that is the respondent number 2. Ms. S. Borwal and a government advocate are some press for some time to obtain instruction in the matter. NOM 6 weeks since Ms. Borwal has appeared and accepted notice for respondent numbers 1 and 2. No formal notice is required to be sent in this case. The said respondents, extra copies of the writ petition be furnished to the learned government advocate Asim so as to enable her to obtain instruction. Petitioner will take steps for service of notice upon the respondent number 3 by registered post within 3 days from today. It is made clear that pendency of the writ petition shall not come in the way of the respondent number 2 in expediting the process of disposal of the pending Bakijai case if so advised, in accordance with law if so advised.
Deeply right.
Item 22.
Yes, who is appearing?
Item 22.
None appears, so the petitioner will call. Let this matter be listed again after.
Supplementary list of persons, item 51.
May it please, your
There
lordship.
was a possible matter actually.
Look, the respondents, they have filed an affidavit.
May I please, your lordship? Lordship, kindly pass up for time being, your lordship. My senior some legs on court number 1, your lordship.
Otherwise, they have filed an affidavit, my lord. I want to make submission on that, my lord. There is no requirement at this moment for filing the counter affidavit because I'm, my lord, pressing the interim order, interim prayer before your lordships, because something very glaring has come up from the affidavit, my lord.
Lordship, affidavit is already called for, your lordship. Affidavit is coming, your lordship.
All right, you take your seat. I will not pass any order without hearing your senior.
Lordship.
But you cannot stop the
No.
court from hearing him because your senior is
Yes,
not.
lordship.
That
Actually,
is
lordship,
beyond you.
Affidavit is called for, your lordship.
Please
It is
take
done.
your seat.
Yes.
Yes. Yes, what is it you want to show?
Firstly, my lord will come up first glaring illegality. First glaring illegality.
What is the order? Read the order, please. First, last order.
Last order, your lordship was pleased to direct the respondents to file a short affidavit.
I have filed affidavit.
Yes.
my lord, what they have done, my lord, they have issued an advertisement for filling up of the post. My lord, they have conducted a written examination. My lord, written examination, prelim examination contains two papers, GS1, GS2. In GS2, there is a cutoff mark of 60C, and GS1 is the, my lord, eligibility paper, my lord, wherein from where the final, my lord, merit list will be prepared. My lord, immediately after the, my lord, prelim examination, my lord, they publish the provisional answer key. We, in our question paper, we mark the questions that we have answered as well as the options we have ticked, my lord. My lord, we are, since we are continuously participating in this few of the petitioners, they are confident on that. We compared our marks with the provisional answer key, my lord. And in the writ petition, my lord, I have given a chart wherein that is our assessment of marks. There are negative markings also, my lord. We have considered that too in calculating our marks. Now, it is the obligation on the part of the APSC to publish the final answer key, because in the meantime, there were objections from candidates with regard to, my lord, incorrect answer key. They, in GS2 paper, they corrected 5 questions, 3 questions, they, my lord, corrected the answer key. 2 questions, they say that the options were incorrect. So they gave mark to all of those 2 questions. And in GS1 paper, they corrected 2, my lord, options. My lord, after this process is undertaken, for the fairness and fitness of the things, they are required to publish the final answer key. Because otherwise, how the candidates will know which question was corrected, which question options were wrong? Because we have also made certain objections before the APSC authorities saying that these are the questions which questions the answer key was wrong. The candidates are absolutely in, my lord, dark. What are the questions that are corrected? There is a direct Supreme Court judgment wherein this Honorable Apex Court has said at least this level of fairness is to be maintained by the, my lord, examination conducting authority, that you are required to publish the final answer key. That is one aspect of the matter, my lord. Till date, they haven't published the final answer key, and their explanation in the affidavit is that it will create a chaotic situation. That's why the final answer key cannot be, they cannot publish.
You also don't know what is the final answer key.
No, my lord, nobody knows what is the final answer key. So there are, my lord, answer is that since there will be some havoc, my lord, there will be disturbance or confusion, so we are not publishing the final answer key. That is one aspect of the matter. Second aspect is that the most glaring is that if your lordships kindly take the page 151 of the writ petition, by which the APSC authorities, they give the cutoff mark and they corrected the questions, my lord. Annexure P8, page 151.
Yes, so where is the final answer key?
Lordship, the final answer key has been checked by a way of expert and same was put in the machine.
Give it to us tomorrow.
Tomorrow.
Yes.
Lordship, I'll-
Produce the final answer key. Give him a copy. Let them go through it. Day after
Another
tomorrow.
aspect, my lord, I just add.
So Mr. Das, first final answer key. You have to go through it.
Yes.
And file affidavit telling which are the questions you
Yes.
have been wrongly marked.
Yes,
If they can't give a satisfactory reply, we'll call for the records.
my lord,
If we find it is correct, we'll set aside the entire process.
my lord.
No interim order.
I am absolutely in agreement with your lordship.
No interim.
Only one more prayer, my lord. Because there will be uncertainty till the last if the OMRs, original OMRs are not given. Because today I have claimed that these are the answers I have given. Tomorrow they will say that no, these answers, you haven't ticked this answer. So to eliminate that confusion, my lord, at least our OMRs, at least photocopy, let them keep the original. At least the OMRs, photocopy of the OMRs may be provided. I'll file a detailed affidavit in reply, my lord. Lordship will hear the entire matter.
It is not their pair, my lord. Your lordship kindly see their pair, my lord.
No, lordships can.
No, just a minute.
I'm sorry.
See, the controversy in this case is on one point, that the marks given to them is not in accordance with the final answer key.
My lord.
They have answered correctly, but
No, final answers key, he has not yet to get, they are not getting final answers key, my lord.
No, they are getting it day after tomorrow because we'll order it.
Oh, yes.
Yes. You bring it to the court.
Yes.
Then we'll
Final,
see.
final.
Final answer key
No,
and the OMR sheets of the 10 petitioners.
my lord, at this stage, it will be difficult, my lord. Because your lordship kindly see, yes, we'll provide it in due course of time. Because my lord, we are handling 75,000 people, my lord. Now, my lord, come down to 10,000, my lord. If everybody will come to the court and say they're asking, my lord, it will be very difficult for. We'll provide it. Again, they can inspect it. There is a provision also, but not this stage, my lord. Let us complete the process, my lord.
They have come, we are not going to entertain other petitioners. We are not going to, if we find that their allegations are unfounded, heavy penalty, we'll bar them from appearing from APSC in future. These matters are serious both sides.
My
As we
lord,
appreciate that.
I
APSC also-
agree, my lord.
If these allegations turn out to be incorrect, the court will issue notice and ask them to show cause where they should not be debarred from appearing in any exam of APSC in future. And if satisfactory answers do not come, they will be debarred.
No, what is
This
their
can't be a
allegation,
like,
my lord?
let's
No, no.
take a chance and
I will answer that. What is their allegation, my lord? They said that I am entitled to get 78. In fact, they are getting 78, but they have not minus what there is a minus mark system. They have not negative mark, they have not minus, my lord. In my affidavit, correctly, I have everything I have stated, my lord. Your lordship kindly see.
all right, where is the affidavit?
Yes, my lord.
Is it on record?
Yes, my lord. It is. No, that is, your lordship.
While we calculated, my lord, we have calculated, going by the provisional answer key, the negative marks we have calculated. But we don't know what are the answers you have corrected. So there, because lordship will kindly
So
say.
why
two
don't
marks
you
each.
just give the final answer key before the court?
Code, yes, code we can. Yes,
We'll allow him to inspect it, that's all.
my lord.
That's all.
Yes.
Answer key and OMR, my lord, with all due respect. With
OMR, I'm declining as of now.
My lord, kindly, because I cannot file my affidavit if I can, again, things will be disputed. Since your lordship is
Mr.
asking.
Das, learned counsel for the writ petitioner also have
Only
Mr.
can hit
Peter Mahanta,
2019 also.
learned senior counsel appearing for the APC who submits that in terms of the order dated 3/5/2023, affidavit has been filed today.
Yes.
Today,
No.
Yes,
No, 9th. As 9th, my.
yesterday.
I have copied.
That is 9/5/2023 by serving advance copy upon the petitioner's counsel. However, the said affidavit is not available on record. Be that as it may, since the entire controversy in this writ petition pertains to in this writ petition ultimately leads to the final answer key, which was not published by the APSC. Mr. Mohanto to produce the final copy of the final answer key of General Studies papers 1 and 2 before this court on next day, that is 15/5/2023.
My lord.
Register to list the matter again on 15/5/2023 by tagging the affidavit of the APC, the record of this. Yes, Mr. Das, we are not bothered about whether your clients get it or not.
My lord,
All we are bothered about is to see whether
fairness
there
of
is
the
any
selection. Yes,
unfairness in the process.
absolutely, my lord. I bow down to your lordship. Only thing,
Because
my
it is
lord,
not possible. If today 5,000 people come and say that we have not got the marks we wanted, what, can we entertain
lord,
it?
I appreciate your lordships, but the thing is that the 5,000 people is not before your lordships and only 10 are before your lordships.
You will see on Monday what happens. Wait
At least
till
the
Monday.
OMRs may be brought. my
Wait
lord.
till Monday, you will see. Without the OMR, how do you make out a case?
Even I can make out a case, but for the, so that the things are not get delayed, my lord, if the OMRs are there, I can file my reply, entire thing can be
Nothing
settled.
doing. You are not going to sit in the final mains. Either the selection process will be quashed or it will go ahead.
Lordship.
Your clients are not going to sit in the mains on the basis of any order in
My lord,
this.
I am at this
Let that
moment
be
not
very
pressing,
clear.
my lord, I am at this
That is
moment not
over.
pressing for permitting me to mains. I am only on the, my lord, merits of the selection process
Then
and
we
all
will
this
see
thing.
what is the urgency.
That is why, my lord, I ask for the OMR, my lord. At least because prelim examination we have failed. OMR, they are going to, they are not going to do anything, my lord. Ultimately.
Why do you want the OMR day after tomorrow itself?
I am sorry, my lord.
Why not after 1 month? Why?
My lord,
Give an answer. Why?
The reason is that if the OMRs are furnished.
If
my
the
lord, I
OMRs
will
come
be
day
able-
after tomorrow, and if it is found that your client is correct, then what will happen?
Entire selection will go.
Why, it can go after 1 month also? What is the urgency?
There is no urgency, my lord.
So
I-
there
I
are
thought-
questions the court is contemplating.
Yes, yes, my lord. Much
We
obliged,
we will go into things in a balanced manner.
my lord,
Yes.
highly obliged. Yes. Deeply obliged.
An application for modification of the orders.
Which
passed.
order?
My lordship will kindly have. The internal application.
What is the
my
date
lord,
of
at
the
page
order,
11,
Mr.
my lord. Date of the order is, my lord, 21st of 21st of October 2020, my lord.
What is there to be vacated in
My
this?
lord, I just have to place a little history of.
The
what-
first you tell us what is
Yes.
there to be vacated.
The petitioner's challenge in the writ petition was to the promotion of respondent number 6 to 8 in the writ petition.
Hmm.
He has included everybody who was promoted, even his seniors, in the memo of parties.
Hmm.
Although he's agreed by the promotion of only respondent number 6 to 8 per his pleadings in the writ petition. This order, my lord, keeping it all subject to outcome of the repetition.
We'll vacate this order by making it clear that this will be subject to outcome of the writ petition. Is that the order you want?
My lord, what I,
An order saying that a promotion given will be subject to outcome.
what I was.
How can that be vacated?
My lord, I'm not asking for a vacation, I'm asking for a modification.
What is
has
the
happened?
modification?
The persons who were senior to him and whose promotions were not challenged, those persons, some of them have retired, some of them are already serving in the promoted post.
Hmm.
Persons who have already retired because of this particular order are now being given the pension only at the rates which they would have got had they not been promoted. They are being given the pension at the rate of the earlier post.
Hmm.
There being no challenge to their promotion in the repetition itself, the pension is suffering. That is one aspect of the matter. Those who are already serving are being paid the salary of the earlier post and not of the promoted post. If I may just take lordship.
He has challenged the promotion of which respondents?
My lord, he challenged respondent number 6 to 8 in the repetition.
Hmm.
And the promotion of everybody in that select list has been made a subject to outcome. Retired persons are not getting their due promotion.
We'll clarify that, then you say it's a order clarificatory order.
Yes, if they get their salary in the promoted posts, if the salary of the other applicants are given in the promoted post and those who have already retired, they are given their pension due on their promotion as if they have been promoted. But I would have nothing more to say in the repetition.
No, Lordship,
I have nothing more to say.
my humble submission before this honorable court is that, Lordship, I have challenged the notification dated 19/9/2020, I have not stated that I have specifically challenged the promotion of such particular
Lordship
person.
will
Lordship.
find page
Because
23 of
I
the
have
repetition, my
challenged
lord.
the selection process,
Whose
Lordship, and the
promotion
selection
is challenged? Page
which was
23,
done-
para 20.
which was done without having any service rule as well as non-compliance of the OM that has been passed by the department itself. And also there is some means disputes in terms of the selection.
Lordship may like to have page 23 of the repetition, para 20. 6 to 8 is whom he challenges. Page 25, 6 to 8 is whom he challenges. Then Lordship will have the main prayer 2. He challenges 6 to 8. At page 28. Then Lordship will have prayer 3. He challenges respondent number 5.
That
The
is a
rest of
statement,
the
that is a
rest of them are-
statement, Lordship. That is a statement. I have to categorically state. it.
Mr. Majumdar, I'm not understanding one thing. If this order has been wrongly understood by the department,
My lord, yes.
then you should file your own petition and get a clarification.
My lord, this honorable court, my lord, has stated the promotion of all.
State the
I am
promotion.
sorry, my lord, had made all the promotions subject to outcome of the repetition.
Yes.
Department in their understanding that if something goes wrong, we will not be able to. All the others who are not even under challenge
Hmm.
are now, my lord, suffering. That is the only issue, my lord.
But why they have been treated as respondents in the writ petition?
Oh, my lord, he has made them parties and that is all. No allegations against them. Not a sentence in the writ petition. against them.
Therefore, was it not required for you to file a writ petition to assert your client's right?
My lord, when everything is subject to outcome of the writ petition with this
Yes.
order existing, put my other writ petition. my lord.
That is the observation which could have been given in the other writ petition.
The writ petition could not modify this order, my lord.
I'm so sorry, nothing can be done. here.
But
There is
otherwise-
no order against you.
My lord,
The court has simply said promotion given will be subject to outcome. What is there to modify in this writ petition?
our promotions may not be subject to outcome of the writ petition when there is no challenge.
Then you are aggrieved, you come to the court with your grievance.
The IA for that only.
IA will what to do? There is nothing to modify in this order.
And
In this IA, relief can't be granted to your client. Nothing is there which requires modification. The court has mainly only said issue notice, take steps. Promotion given will be subject to outcome of writ petition. There you want to file an IA and get a relief that give this to the petitioners, give that to the petitioner.
no,
How is it permissible?
this
What
subject.
is the
Making
observation
our
you want? here?
promotions, making our promotions subject to outcome of writ petition is what I understood, my lord, must be
That
placed
is
with-
a matter in the merit. It can't be. It can't be.
when the writ
Your
petition will
client
be
is
taken up-
aggrieved that despite promotion, they have not been given pay scale. You come to the court, we'll ask them why you have not done. If they say it is because of this order, then we'll pass. There could be other reasons also.
But that is the reason which.
That, where is the letter? They have informed you.
not-
Send
not-
a
not-
SMS,
not-
WhatsApp.
Not in so many
Then-
words, but there was an order from this honorable court also. Well, could the matter be taken up?
File a writ petition, we'll pass orders.
In
If you
this
are
writ
aggrieved.
petition, could the matter be taken up for final disposal since pleadings are complete, my lord? Even that would suffice my.
Nothing. You are aggrieved, you file a writ petition, will grant you relief. Devising the method which for the court. You can't say that because this matter is handed, so you hear the writ petition day after tomorrow. and pass it. That kind of things will not cater to Mr. Lee. You are aggrieved, you come to us, we'll see what is your grievance and give you relief, as simple as that. Because tendency of this petition, if it is disposed of early, that will help you, so the court should sit and hear the matter early. This kind of prayers, this court will not entertain. If you are aggrieved to come with a petition, we'll give you relief. Heard Mr. R, from the Learned Council for the petition. Also heard Mr. D. Sharma, Learned Council appearing for the OPD petitioner. Miss
1 and 3. Arbor.
so and so for 1 and 3, Ms. S. Borua for 4 and Mr. Ardhar.
Lordship, notice upon the respondent number 18 may be issued, Lordship.
Nothing. You didn't succeed here. It is just that his procedure is not correct. His IA has been filed with a prayer to modify the order dated 21/10/2020 passed by the Learned Single Judge in WPC number 4373 of 2020, whereby it was observed that any promotion given to the respondents would be subject to the outcome, subject to the result of the writ petition. First up, the applicants herein were included as respond numbers
They were implemented respond number 4 to 16, my lord.
4 to 16 in the writ petition, including 6 and 8. 6 to 8.
No, 6 and 8 are not here, madam.
Then why are you saying 4 to
My lord,
16?
14 to 8, 17. Lordship.
14 to 17.
14 to 17 in the connected writ petition. Mr. Majumdar submits that although the challenge in the writ petition is to the promotion of respondent numbers 6 to 8, yet due to the pendency of this writ petition, his clients have been denied regular pay in the promoted, as per the promoted scale,
And the pension.
and the pension for those who have retired in the meantime. Full stop. After hearing Mr. Majumdar, this court is of the opinion that the order dated 21/10/2020 simply mentions that the promotion given in the meantime will be subject to outcome of the writ petition. Full stop. There is no order of restraint of any manner passed by this court. Therefore, the question of modification of the order dated 21/10/2020 does not arise in the eye of law. If the petitioners are aggrieved in any manner due to non-payment of regular pay scale, public pension, then the same would give rise to a separate cause of action for which they will be entitled to approach this court With the above observation, these IA stands disposed of.
Deeply blessed.
Highly obliged.
For admission.
Your lordship may kindly take up IA civil number 1195 of 2020.
No, first of all, what is this matter?
Well, that matter relates to that distribution of the retired benefits among the husband who is a Oil India doctor and the wife. And during the course of the hearing, the proposal was we gave 50% to pay them. But since the sons and daughters were not party to the proceeding, so a consensus could not be arrived at. So we have filed an impleading petition to implead the son and daughter as a party respondent, and we'll take steps during the course of the week. We'll fix up a date, but let them come and respond, madam. And our offer of 50% is open, madam, still today.
All right, but today notice has to go in the IA.
Yes, madam.
They have to be implemented first, man. And we have no objection.
They have no objection, and,
But the
because
note-
the mother,
Let them be implemented and we'll issue notice in the writ petition.
the mother can espouse the cause of the children because the children are with the
But
mother.
that is for them. If they-
Well, notice is
You are appearing for,
All India Limited respond 1 to 6.
So notice will
you will go by the court order.
Yes, your lord. We are only holding it in custody, no, the money.
No, but have you given their registered address? We'll issue notice whether the mother.
They have
comes-
the implement, they have no objection, my lord.
All right, heard Mr. B.D. Cole, and senior counsel listed by
Yes,
Mr.
sir.
H. Agarwal, learned counsel appearing for the applicants. Also heard Mr. J. Patwari, learned counsel appearing for the OP respondent number 7. Mr. A. Sharma, learned counsel has appeared on behalf of respondent numbers 1 to 6. This IA has been filed with a prayer to implead the opposite parties numbers 1 and 2. That is
Respondent number 8 and 9.
Srimati Shivangi Gogoi and Sri Rustak Gogoi as respondent numbers 8 and 9 in the connected writ petition. Full stop. I have perused the statements made in the IA and find that the interest of the respondent numbers, opposite party numbers 1 and 2 is required to be protected in this case. Full stop. Therefore, the prayer for impleadment appears to be just and reasonable. Mr. Patwari, learned counsel for the OP number 7 submits that he would have no objection if the prayer is allowed. In view of the above, the OP numbers 1 and 2, namely so and so, are directed to be impleaded as respondent numbers 8 and 9 in the connected writ petition, registered to make necessary endorsement in the cause title, and thereafter this the matter for orders. IA stands disposed of. And in writ petition, you write, heard Mr. So-and-so, Mr. Kumar Lanet, senior counsel, listed by so-and-so. For the writ petitioner, also heard Mr. A. Sharma, Lanet SC. Oil India Limited, appearing for respondent numbers 1 to 6. Mr. J. Patwari, Lanet counsel, has appeared for respondent number 7. Issued notice returnable in 4 weeks on the newly impleaded respondent numbers 8 and 9. Petitioner to take steps for service of notice within 3 days from today. Full stop. On the next date fixed, Mr. Patwari to also obtain instruction and appraise this court as to whether he can appear for the newly impleaded respondent numbers 8 and 9 in this case, since their current address is one and the same as that of the respondent number 7, who is their mother.
Then we'll furnish the extra copy to my friend.
No, let him obtain instruction, but you take steps because these are court proceedings. Let notice go at least.
Yes, yes.
Whether they appear or not, then we may draw presumption. If he says no, we'll draw presumption. That's all. Yes. 5 minutes.
Lordship, this is for termination of a contractual appointment of the petitioner, Lordship. He was appointed in the year 2012 under DRDA, Lordship, and thereafter, time to time, his service was extended. And in 2017, Lordship, they have terminated without any serving notice, Lordship. And
Very good,
similar
very
matter
good.
already, your Lordship has decided, I have placed the order, Lordship. It was tagged matter, but due to the absence of a letter, Lordship, which was annexed in additional affidavit, Lordship, page 64. The matter has not been disposed of on last occasion, Lordship. Termination order is 44, Lordship, and 64, Lordship.
Yes, what do you have to say?
Lordship, page 64, my lord, this is the main order, my lord. That is not under challenge, my lord. That is technical problem in this writ petition, my lord. The main order is, this is the main order, page 64,
Because Lordship,
but this is not under challenge.
this order was not supplied by the department to the petitioner, Lordship. Only page 44, Lordship. Page 44, Lordship.
Page 44 is the compliance order of this page 64, my lord. Passed by the deputy commissioner.
And his appointment was for how many days, for how many years?
That was over, my lord, for 1 year only.
But it was extended from time.
No, no, my lord, not extended. Petitioner failed to supply those documents, my lord. Contractual period is already over.
Initial appointment was for Lordship 3 months, Lordship, and thereafter it was extended time to time. Up to 2017, I have annexed lots of document, Lordship.
Hmm. So what order you are seeking now? What is the order you are paying for here?
Lordship, to setting aside the impugn order, Lordship, termination order, and restore him in service, Lordship. And not only the
But
petitioner.
main order
Lordship,
is not under challenge. This is the termination order, main order.
because this order was not supplied by the department to the petitioner, Lordship, only in page 44, Lordship, even your
But
Lordship.
now you know.
Yes, my lord.
Yes,
After
yes.
getting this, he can challenge it.
I have filed an additional affidavit, Lordship, and produced before your Lordship.
Hmm.
Filing of additional affidavit will not improve his prayer, my lord. With due respect, my lord. Huh? 44. Page 44 of the petition. Or additional affidavit cannot be sent. Like that.
Where have you stated that this order needs to be set aside? 24 January 2018.
No, my lord. Lordship.
What is the statement in your additional affidavit?
Paragraph 3, Lordship.
Hmm. Hmm.
But the respondent number 1 by impugn order dated 24/1/2018 brought allegation against the petitioner for gross negligence, absence and indiscipline in service regarding the promotion of PMHY and activities in his assigned development block of Panchayat, Lordship, and submission the report without verification and considered suitable for termination of his contractual wherein he had been engaged as accredited engineer of the Borkola development block under the district Kachar, Lordship.
Where is the prayer to set aside the order dated 24 January 2018? I am asking you.
Lordship,
You have not made that prayer. I'll dismiss the writ petition.
Lordship,
Or
I
you
may be-
withdraw with liberty to file a fresh challenge in the order. These are the two options available to you.
I am allowed to file an additional affidavit.
No, 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 you will not allow it. How many additional affidavit you file?
Because it was came on light later.
You want to withdraw or you want me to pass a judgment?
Withdraw, Lordship.
Huh?
Withdraw to file a
All
fresh
right.
lawsuit. Liberty may
Mr.
be
T.
granted.
H. Chaudhary, learned counsel for the petitioner submits that since the copy of the office order dated 24/1/2018 was not furnished to his client earlier, hence the same could not be assailed in the writ petition. Full stop. Therefore, he seeks leave of this court to withdraw this writ petition with liberty to challenge the order dated 24/1/2018. The prayer is not opposed by Mr. S. Dattal, learned standing counsel PNRD Assam, as well as Ms. S. Borwal, learned government advocate Assam, appearing for the official respondents. In view of the above, this writ petition stands disposed of on withdrawal with liberty as paid for. Even in the additional affidavit, if you would have made a prayer to set aside,
Let's
I would have accepted it. You have not done it.
Obliged.
In this case, my lord, senior counsel Vihidash is coming, my lord. Just few minutes.
What is this matter about?
Look at that, my lord.
What is this matter about?
My lord, the petitioners, my lord, are the employees of the DRDS. Subsequently, my lord, they are absorbed in the, my lord, PNRD in a sanction vacant post, condition of their seniority. And now they are claiming for, my lord, a common gradation list.
What?
আমাকে কত নেবো? সাবজেক্ট নম্বর এটা? Yes, Mr. Das.
What it is against a combined gradation list, that is against. We are originally in the DRDA. Now that was merged with the line departments. With the protection of seniority. And therefore, there should be a combined gradation list. Because we are absorbed in the line department.
In what department? Line department.
Everything is PRC, not PNRD department. They say it is line department. Now they are trying to maintain a separate gradation list for the original employees as well as the absorbed employees. That is our grievance.
Yes, Mr. Datta. How can you have two lists for
Yes, my lord.
employees in the same cadre?
My lord,
The petitioners are absorbed in which cadre?
my lord,
Cadre?
the DRD employees, my lord, DRDA was dissolved
That's not the question. You
My-
first you answer the court question,
Yes, my lord.
then you go on saying whatever you want.
Cadre.
These writ petitioners are all in the same cadre.
Not exactly, my lord. Not exactly, because from 2017, my lord, they were absorbed in the department. And for their protection,
Mr. Das, could you please throw some light on this? All the read petitioners are in the same cadre.
Yes, yes,
Same cadre.
simple.
What is the cadre?
Senior assistant. Now they have been absorbed as all the them senior assistant in the PNRD department. Absorbed.
All the petitioners are presently serving as senior assistant.
Huh?
So they are maintaining two seniority lists of senior assistant
Yes.
in PNRD. One of those were originally in the
Original.
department, another were
They absorbed employees.
observed employees. So how can you do that?
Before absorption, my lord, they were not a regular employee of the state government and not working against sanctioned post, my lord. Therefore, my lord, their rights comes on 1/8/2017 itself from there, my lord. And other employees, my lord, they were working since long, my lord, from in the department, my lord. Therefore, if we, after absorption, my lord, if we will amalgamate all the employees, my lord, it will
It will what?
chaos, my lord.
What
Create
it-
chaos, my lord.
What chaos?
For that, my lord, the absorption itself, my lord, clause 9, there is a point, my lord, and they have accepted that, my lord.
What
Lordship,
is
may
it?
kindly
Page number?
take up my affidavit, my lord.
Yes.
Paragraph 22. Page
Yes.
12. Paragraph 22, may I read, my lord?
Paragraph 20, what is
Of
the
my
page number?
affidavit, my lord.
Page number?
Internal page number 12, my lord.
What is the running page number?
Running page number 66.
Affidavit in opposition by respondent 1 to 18.
My lord, yes.
Yes,
May I read, my lord?
yes.
Fourth line, my lord, I am reading.
Internal page number 12.
12.
Yes.
Fourth line. It may be reiterated that the DRDA born employees were not government employees prior to their absorption against government sanctioned post. As such, their past services, non-government period cannot be merged with the employees working against government sanctioned post. On the other hand, if we consider the seniority of DRDA born employees with effect from the date of their absorption, that is 1/8/2017, then these DRDA born employees have to be deprived from the promotional benefit. With a view to give them promotional benefit to DRDA born absorbed employees, and as per criteria point number 9 of the government notifications number so and so dated 12/9/2016, the government in the Panchayat and Rural Development Department had issued instruction for preparation of separate gradation list for DRDA born employees, counting their past services rendered by them in DRDA, non-government period, for non-government period, my lord. As such, intention of the government is found to be in favor of the DRDA born employees for giving them promotional benefit, my lord.
Mr. Das is correct.
My lord.
I will allow the writ petition, but your clients will be downgraded immediately.
Yes, my lord.
Your clients will get seniority on the basis-
Your lordship wish to see our seniority was protected by their own order. Page
No,
52.
Mr. Das, please understand this. If there is a common gradation list, then the seniority will be counted with effect from the date on which regular appointment was made. If your clients were not working as regular appointees under the earlier DRDA department, then their regular appointment will be treated from the date of their absorption.
Yes.
So therefore, your clients will lose out on seniority. If you want that, fine. Otherwise, final hearing in.
But in page 52, they say that your lordship wish to see page 52 of the writ petition.
Yes. Yes. In fact, I find they have done something which you should have asked for.
Yes, my lord.
And by doing this, they are going to be in big trouble now. Your clients will only be the beneficiary of this process.
But my lord, they have,
They have,
Otherwise, if there is a common list,
no.
they just come below the earlier employees.
No, by page 52, they protected our seniority.
They protected your pay,
Yes,
not seniority.
there is no gap period between the date of discontinuation from DRDA and joining the AP's development block.
So please think
and
about
GPs,
this,
etc.
even if they are protected.
Yes.
If they prepare a common list, if somebody comes and
Yes,
challenges.
we want that. We want that if somebody, because if separate gradation list is prepared, then what percentage of promotion quota will be fixed for us or for them? This is not known.
No, if there is a common list, there is no question of quota.
No, if there is a common gradation list, there is no quota. But now they are,
Please, just a minute. You see, they say that many of your clients were not even regular employees under the DRD.
yes.
That you agree?
Yes.
Now, they were absorbed into the PNRD department, and at least with effect from the date of their absorption, they can be, whether or not it is perfectly acceptable in the service jurisprudence is another matter. But at least from the date of their absorption in PNRD, they will be treated to be in regular appointment, correct? Now, therefore, those who were not in regular, whose services were not regularized earlier, they will obviously come below those services were regularized earlier under the PNRD, above you. Obviously, they'll come, regardless of what government says, what notification. That is the principle of service jurisprudence. Anybody challenges, the court will pass that order. So the question doesn't arise. Would you want to be in that situation where all your clients are below those who are already existing there because your clients did not have a regular appointment? Think about this. Would you want that? You can't say that, all right, make one list and put me in the top. That is not
No, I am not saying so.
Then you will
I-
come below them.
Yes. That is what they say, but we
Yeah, that
want
is
to
correct.
say.
That is correct. They will come, you will come below them. But if they maintain parallel list, then they can say that, okay, out of this promote quota, we'll give 10% to people coming from this list.
They must say so.
Paragraph
they-
5 of my affidavit, my lord.
That's what, have you said? so?
Yes.
That they have given a calculation,
Calculation
but
is
it
there.
is not clear. Page photo.
That is why I think if the repetition is allowed, it will be disastrous for your client.
Yes, my lord.
Disastrous. simply.
58.
Maybe Mr. Koyum has not been able to brief you properly. Mr. Das.
No, they have given a calculation.
That's right. They want to create some space for your clients. That's why they are doing it. The other employee should come and challenge it. You are coming and challenging. You want something to be done which will straight away help the other group. Then there will be a bundle of litigations. Promotions will be stayed. Department cannot go right, cannot go left. These fat briefs will come. The courts will take 5 years. What is the point? Think about it. If you still want it, I am ready to hear.
Paragraph 5 of the page 58.
Hmm.
But if they can clarify this one, paragraph 5 of the page 58 of their affidavit, they've given certain calculation, but it is not understandable. What they want
That
to
is
say.
another matter, but just because it is not understandable, you will challenge something which is suitable for you.
No. They want to say something. So as if something has been given to us, but who is not in a position to understand. Let them clarify it. They've given certain mathematical formula.
So why do you want to maintain the other gradation? Gradation list is only for promotion.
My lord.
So are you considering separate promotional avenue for them?
Yes, my lord.
Where is that statement? The only reason why a gradation list is mentioned
Lordship
is
may
for
kindly come
using it
to
for
for a
promotion.
movement, my lord. Lordship
Yes.
may kindly come to page 39 of the writ petition, my lord. This is the notification, my lord,
Yes.
by which DRDA employees were absorbed in the department. Then page 40, my lord, last paragraph. This is the clause 9.
Hmm.
May I read, my lord? After absorption, promotional avenue of the DRDA employees will be as per government existing rules and regulations and separate cadre-wise gradation list for the inter-seniority of the absorbed personnel shall be maintained in the concert ZP autonomous councils and also in the PNRD
Good,
department.
very good. So that means you are contemplating to keep some promotional post reserved
Yes,
for
yes, yes,
this.
my lord.
What is that promotional quota and how have you implemented it by
lord.
amending the rules? Tell us.
My lord.
What is the promotional quota?
My lord, paragraph 5 is the mathematical calculation. I'm also not 100% getting it, my lord.
Not 100% getting it. Have a look at it.
Yes, yes.
Perhaps this writ petition will do more damage to your client.
Let them also explain paragraph 5 of the affidavit. Let us understand it. But management possibly is also not in a
But you have to amend the rules. Where have you done it?
I'll take instruction.
There is
on
no
that.
rules. my lord.
I'll take instruction on that, my lord.
No rules. Yes.
Then if there is no rule, there should be a notification.
I'll take instruction.
The
Otherwise,
cabinet-
we are trying to help them, my lord.
Cabinet decision has to be notified.
My lord.
Let us not complicate the situation. If it can be sorted out, we'll
Yes,
have it
yes.
after 2 weeks.
So after 2 weeks, my lord.
After
Mr. BC Dal, and senior counsel, Mr. Mr. B. Learned counsel is present on behalf of the petitioners. Mr. S. Datta, learned standing counsel, PND Assam submits that creation of two separate seniority lists is to protect, is aimed at protecting the interest of the petitioners who have been absorbed into the PNRD department from the erstwhile DRDA department. But the manner in which such protection is sought to be implemented by providing promotional avenue to the writ petitioners and similarly situated candidates absorbed into the PNRD department. In the promotional post by maintaining a separate gradation list is a matter on which he would like to address the court after completing his further instructions.
My lord.
In view of the above and on the request of Mr. Datta, this matter is directed to be posted for admission again after 3 weeks as fixed
2
item.
weeks.
In the meantime, you also please examine.
Yes, yes. In the second week of or first week of June.
After 3 weeks will be first week of June. Yes. It will be either first or second only.
I'll have done. My lord, in 28, affidavit sent for waiting, my lord.
Mr. M. Mondal, learned counsel is present on behalf of the petitioner. Mr. S. Datta, learned department counsel submits that the affidavit has been sent for vetting and therefore he be granted 2 weeks.
2 weeks time.
It will be same on the record.
My lord, similar issue has been fixed this month, my lord, on 16, your lordships. Can it be fixed on 16th, my lord?
No, that will matter first. Let this writ petition be listed again after 2 weeks. In the meantime, the affidavit
My
is
lord.
brought on record. We'll see. We'll see.
My lord, a date may kindly be fixed, my lord.
Oh, all matters we can't fix dates. Dates are only limited.
Like-
Cases are unlimited.
Highly obliged, my lord.
Yes.
May I please, my lord? My senior is engaged in another court.
We'll pass it
Right.
over for the day, as paid for by petitioner's counsel. These matters will pass over for the day. Mr. K. Gogoi, learned, CGC is present on behalf of the respondents. Yes.
Okay.
May I please, your lordship. Lordship, in this case, your lordship had directed me on 28/2 to take remedial steps. But unfortunately, my client is indisposed. I have not been able to for the last few months. He is in Delhi for his treatment, your lordship. But however, your lordship, a point I just want to place before your lordship.
No, why this matter was adjourned?
Because your lordship, if your lordship comes to annexure F at page 71,
what had happened is your lordship had made a query because after we gave a notice under section 11, there was another notice given by us under section 11, where there was no specific statement with regard to arbitration. However, if your lordship kindly see annexure G first of all, your lordship, page 73. This is the section 11 So in notice. the notice, you have not mentioned about arbitration. In your lordship will finally see annexure G. Here in annexure G, we had mentioned at page 73. At the last page, we had at the page 74, we had stated that we intend to go for arbitration. 75, we had made the specific request. 11.5. 75 is the last para, where we have specifically stated that appointment of an arbitrator, and if they fail to do so, they will we will take the request before approaching this honorable court seeking appointment. Now, thereafter, in annexure H, the respondent asks us to reduce the claim because there is a clause in the with the railways that if the claim exceeds a particular percent of the contract value, they cannot send it for arbitration. So they asked us to reduce the claim with regard to the claim we made under section 11. In compliance to that letter of theirs, we reduced our claim by a subsequent letter. Now, in that particular letter, reference to arbitration was not there. Okay. However, this was in continuation with the earlier letter. So my submission before your lordship is, it is not a fresh claim because it is on the request of the railways, we reduce the claim in the what is the date of the subsequent letter? The subsequent letter, your lordship will find 15th March 2022, your lordship. Page 77, your lordship. Annexure I. Now, the respondents received that letter, and that is reflected in annexure J, page 79, which they have referred in their particular letter at reference number 1, that particular letter of ours. Now, by this letter, they started insisting us to waive the claim with regard to 12.5. Issue a letter under 12.5 to waive. There is a clause, as your lordship is aware, that 12.5, the persons any person related to the organization who is there, the past employees, etc., they cannot be appointed. There was the clause that insisted us that we waive that particular clause so that they can appoint, which we did not respond because we didn't feel inclined to go for any such waiver. Then they kept on repeating, instead of appointing the arbitrator, they issued another letter in annexure K, seeking again reiterating the demand for us to waiver, go for a waiver of. Where is the arbitration agreement? Pardon me, lordship. Where is the arbitration agreement? The arbitration clause, your lordship. Arbitration clause or agreement? Agreement, your lordship. The amended, we have given annexure L, page 81. Because the GCC has been amended after the original GCC was 98. Now, after the amendment of the Arbitration Act, they have come up with this amendment. Now, the arbitration clause, your lordship will find that we have given your lordship. Now, the relevant portion, your lordship will find page 83, clause 64.3A1. This will be relevant to our case. That in case where the total value of all the claims added together does not. Today, what is to be done? An arbitrator is to be appointed. Yes, it is the data. Those judgments are brought here. The forfeiture of their right after the expiry of the 30 days period. Your lordship. So who is to be appointed as an arbitrator? I'll just place your lordship. Tata Switchgear was the first judgment. And
quite a few, but these are the two judgments. Tata sub, and the other one which followed was Punch Lloyd judgment. Tata switch gear is para 19, your lordship. And in the next judgment, that is Punj Lloyd's judgment, it is para 5 and 6, your lordship. The main judgment is the data switch gear judgment. Para 19 of that judgment. And there is another judgment of 2013 of the Apex Court, which I am placing here with your lordship. This is para 22, may be looked into. Yes. 2013 judgment clearly says that, your lordship, in the middle of para 22. We filed this instant case before this court on 31/5/22.
All right, what do you have to say, Mr. Gogoi?
In this case, lordship, we have. My lord, may kindly peruse the annexures, lordship, page 79, lordship. Page 79, lordship. This is a letter reference to their demand, lordship. Annexure J, lordship, page 79. Where, lordship, we have asked the petitioner to, lordship, reply regarding the waiver of section, as per section 12(5), lordship. That part they have not replied, lordship. As per lordship GCC, we have to appoint, the railway has authority to appoint their own person to own. As per the clause of GCC, lordship.
So have you sent a reply to letter dated 17?
No, lordship, because
We have, because it is not obligatory as per that, because they wanted, if you want a waiver, you respond, your lordship. Because it, there is a judgment of the this Delhi High Court, we say that the respondents cannot compel a person to issue a waiver. Because a waiver, your lordship will see, it should be a written agreement, your lordship, as per 12(5) of the agreement of the arbitration clause, arbitration act, your lordship. A person cannot be compelled to issue that. We wanted for an arbitration, we are not going to appoint, your lordship will see clause section 12(5), your lordship. Because 12(5), if we sign that, then only this comes, your lordship.
Yes, so who is to be appointed as arbitrator?
lordship, as per GCC, lordship, we have to appoint, lordship.
No, that you have forfeited your right.
Lordship, that part, lordship, he has not lordship answered till today. Even lordship, our stand is there in our affidavit, lordship. The final verification bill was 7/9/2017, lordship. After that, as per the agreement, lordship, within 180 days, lordship, he have to apply, lordship. He has applied, lordship, after all, lordship, 3 years and 2 months, lordship.
Mr. Gogoi, have you read the judgments on this?
Lordship.
11/6, forfeiture.
Officer Rossi, even the latest honorable, that particular issue is pending the larger bench lawsuit.
Which is pending.
Regarding appointment of lawsuit, that part. Appointment by the railway lawsuit.
This is a judgment with the Delhi High Court, your lordship, on the same scenario by
The issue is that lordship, whether railway can appoint the officers or not lordship. In the lordship central organization, it says that honorable three judges bench
No, that is not the issue.
lordship.
That is not the issue.
Lordship.
No argument from this.
Lordship,
issue will be
lordship.
resolved. The issue is plain and simple. There is a dispute. They have submitted a
Lordship.
demand notice under
Lordship.
section 11 on 17th of January 2022.
Lordship.
You received it. Then you said, scale down your claim.
Lordship.
Otherwise, we can't refer it to arbitration. So they accordingly issued a subsequent notice scaling it down. After that, instead of appointing an arbitrator, you tell them that you either give up your, raise your
Lordship.
claim under 12(5). If you do it, then we'll do this. If you don't do it, we'll do. There is no obligation on their part. to
Lordship,
respond
that
to
is true, but lordship, he has to reply lordship, whether he has to lordship.
Why he has to reply? Why?
Lordship.
Because we say so. What is the legal requirement?
Lordship, legal requirement is that as per section 12(5) lordship. If you want to waive lordship, then there should be a written agreement.
No, he doesn't want a waiver. It is your problem.
Then lordship, we can as per as GCC laws. And lordship, our affidavit, we have said that we have given.
Tell me the name of this is one single arbitrator or
Pardon, your lordship.
how many arbitrators?
A single arbitrator, your lordship, as per this amount to acclaimation.
What is the total amount?
As per the GCC, your lordship, three arbitrators, 64 3B, your lordship, page 83, your lordship. may kindly. The tribunal, because where it has
So
not
you-
been
you
waived.
want
off,
63 arbitrators or single arbitrator?
Now
What's the big claim?
The amount is higher than the 1 crore, then it should be 3 arbitrators. lordship.
You'll have to keep paying fees.
But,
As per the GCC lordship,
Amount is 1 crore and God knows what will be the fee. It may be a little more also than 1 crore. Huh?
otherwise lordship, our basic contention is that lordship.
So that contention is not in
Yeah.
accordance with law.
He has not replied lordship.
No, he is not required to reply. That's what we know. You should have either appointed an arbitrator. If not, you have forfeited your right. Whatever else you do is of no consequence. Agree on a date, on a name. We can keep it in the second half or tomorrow. Agree on a name. If you can't, then
second up, maybe.
Lordship, but tomorrow lordship, tomorrow. Tomorrow, day after tomorrow lordship, day after tomorrow. Day after tomorrow. Day after.
All right, I have Mr. Additional counsel for the petitioner. Also have Mr. K. Vijay, and standing counsel. I have a railway and 6 posting of this matter again day after tomorrow. So as to enable to obtain updated instructions. They are allowed to release this matter again.
It will be 3 crores, your lordship, as per the amended.
Find out everything and then I will see on 12/5/2023 as it's title. You take back this, give it to me again.
Yes.
In this,
Yes.
finance department.
Lordship, in this matter, we were required to file an affidavit. My lords have gone for signature, my lords. Lordship can grant us 7 days time, we'll file the affidavit. If my learned senior.
Mr. Chaliya, line of SC Finance. It's for 7 days time and last chance to file the affidavit, which according to him has gone for
For signature,
signature.
man.
Mr. Ms. D. Bozai, line of counsel is present and does not have any objection. In view of the above, let this matter be listed again after 10 days.
Lordship.
May it please, your lordship.
Lordship, here in this case, Lordship, the affidavit is sent for vetting, Lordship. It's a,
How much time?
Lordship, 10 days, Lordship.
The RM Deccan and Council is present for the petitioner, Mr. J.K. Goswami, learned additional senior government advocate Assam submits the affidavit on behalf of the department has been sent for vetting and will be filed within 10 days. In view of the above, register to list this case again after 2 weeks by tagging the affidavit, if any, filed by the department.
Interim order was till today, madam. It may kindly.
We'll do it after 3 weeks. Interim order passed earlier to continue until further orders.
No, right.
May I please, my lord?
Yes.
No, the petitioner's father was grade 4, my lord, when he died.
Where is the SLC resolution?
SLC rejection is at page, my lord,
Case number 18.
Says,
page 18, serial number 16. my lord. So, how was Sumatari? He was considered against grade 3.
your application is for grade 3.
No, for grade 4. My father, my lord, died in harness as a grade 4. In application, I have mentioned.
Why was he considered for grade 3? Huh?
His applicant. He has not mentioned.
No, how can we apply, appoint someone in grade 3 with 12 pass qualification?
Then, my lord, I was rejected by saying I am underqualified.
Not mentioned in the.
For our heard Mr. H. Gupta, Learned Counsel for the petitioner, also heard Mr. S. Barua, Learned Government of the person appearing for the respondent. First off, the father of the writ petitioner, who was serving in a grade 4 post, died in harness on 13/10/2023. Thereafter, the writ petitioner had submitted an application seeking appointment on compassionate ground. The DLC of district Baksa had forwarded to recommended the application of the petitioner for appointment. However, by the resolution dated 31/12/2018, the SLC had rejected the same on 2 grounds. Firstly, the 5% quota had already exhausted, and secondly, that he was underqualified.
He applied for get 3 posts.
No.
He had not mentioned in the application where, for which post he applied.
May not be, my lord, at the place of his father only he will.
Mr. Gupta submits that the petitioner had not applied for a grade 3 course, nor was he qualified for the same, and therefore, the ground on which the application for compassionate appointment has been rejected by the SLC is only untenable in the eye of law. The learned government advocate could not point out any material on record to show that the petitioner had applied for a post in the grade 3 category. Moreover, since the petitioner is only a 10+2 pass, he, in all probability, could not have been considered for any post in the grade 3 category. The qualification of the petitioner was only for appointment against a grade 4 post, but from the minutes of the SLC, it is not clear as to whether he was considered for appointment against a grade 4 post. If that be so, the improved resolution dated 31/12/2018, who are the petitioner, was found to be untenable in the eye of law, and the same is accordingly set aside. The matter is remanded back to the SLC to consider his application afresh for a grade 4 post in the light of observations made herein above. The exercise will be carried out and completed as expeditiously as possible, preferably within 6 months from now. The paper received as a certificate copy of this order.
Lordship, and in this case, we are yet to receive the instruction, for which time may be granted, Lordship.
Mr. A.R. Tarvinder, learned counsel is present for the petitioner, and Mr. B. Chakravarti, learned CBC, prays for further 4 weeks time to obtain instruction and file affidavit. Prayer allowed, list accordingly.
Interim order may be completed.
Interim order passed earlier to continue until further order.
Lordship, I have received the instruction and prepared the affidavit for send for vetting, Lordship. So it's order is of state, Lordship, so some urgency is there on our part also. But we have yet to file our affidavit, Lordship.
How much time you want?
Lordship, we'll file as soon as possible, but 10 days, Lordship.
Mr. R. Navindra, learned counsel for the petitioner. On the prayer of Ms. B. Sharma, learned CBC, appearing to the respondents. 2 weeks further time is granted to the departmental authorities to file affidavit. This the matter accordingly.
The interim order continues.
Interim order passed earlier to continue. This the matter accordingly.
Obliged, madam.
My pleasure, Lordship. Lordship, in this case, respondent number 1 into file affidavit of position. So I need 2 weeks time to file in reply.
The learned counsel for the
We have
petitioner
filed our affidavit, Lordship.
prays for and is granted 2 weeks time to file rejoinder in response to the counter affidavit filed on behalf of respondent numbers
1 into.
1 and
1 and 2. Ms. S. Borwell, and Government Advocate Assam is present on behalf of respondent number 1 and 2, and Mr. R. Bhatt, learned standing counsel, Handloom and Textile Department Assam for respondent numbers 3 and 2.
My Lordship. May I please, your Lordship. Lordship, in item number 53, I am appearing on behalf of Mr. H.K. Das, Lordship. Lordship, in this matter, the petitioner has yet to be taken steps, Lordship. Yes,
I'm sorry, Millard, I'm just now told. I will give to them. My
Steps for service on whom?
Lordship, High Court, Millard.
Guwahati High Court, Lordship.
Mr. A. Somal, and counsel for the petitioner, in item 52, applicable. Prays for and is granted 1 week's time from today to complete steps on all respondents not yet served in the matter. Let the case be listed again after 3 weeks with office note. And item 54. Who is appearing in item 54?
Myself, Lordship.
Lordship, in this matter, we have received that Paravas comment, we'll file the affidavit, Lordship.
Mr. Swanso appears for the petitioner in item 54. Mr.
T. Gogoi,
T. Gogoi, line counsel for the respondent numbers
2 to 5, Lordship.
2 to 5. Yes, for 2 weeks further time to file affidavit. Ms. M.D. Royal, and Government Advocate Assam is present on the respondent number 1. In view of the request made by the Learned Department of Council, these matter be listed again after 2 weeks along with item 53.
The consent of both the parties, Lordship, may be, the matter may be fixed for final disposal, Lordship.
What is the matter about?
Lordship, it is about the petitioner has been,
To file an application for modification of the
it
interim
has
order.
been filed by the bank, but senior advocate, Mr. as Datta has informed us that the matter may be fixed for final hearing.
Mr. H. Agarwal, learned counsel for the applicant, submits that he has instructions from his client not to press this IA, and therefore the connected writ petition be posted for it.
No, Lordship, I have not filed the IAL.
Who has filed
The
the
respondent bank has filed the IAL. I am for the petitioner.
All right,
I am
you
the
take
opposed
that.
party.
None appears for the applicant when the matter is called up. Mr. H. Agarwal, learned counsel for the writ petitioner, so OP submits that instead of taking up the IF, the writ petition itself be listed for final hearing and disposal. In view of the above, we need to list the writ petition for admission after 4 weeks.
If we are subject to the convenience 8th of June,
No, after 4 weeks.
of like,
Please, your lordship. In last occasion, honorable court directed to comply the order, my lord, and directed respondent number 3, my lord. But respondent is not holding that post, my lord. New incumbent has joined in that post, my lord. My lord, he is not able to comply, my lord. Respondent number 3, regional director, my lord.
Where is the order dated 12/4/2023?
Is there a direction of personal appearance?
Director personal appearance, my lord.
Which is the order?
Number 3 was order.
There was a direction to appear.
Yeah, the direction to appear, my lord, that is my fault, my lord. I thought since new incumbent has joined in the post, my lord, that's
We
why
have to issue non-bailable warrant against him.
no, my lord, at 2 days time maybe given.
That
That is
is
my
in
fault.
Delhi.
Delhi, no, Calcutta, my lord.
So we'll ask the commissioner of police to arrest him.
No, my lord, the 2 days time may be given, my
He
lord.
has to
Tomorrow,
come on
my lord.
Friday,
Friday, my- yes, ma'am.
personally appear. Court order, otherwise we'll
That's,
issue non-bailable.
that is my fault, my lord.
Master.
Friday, my-
Had Mr. So-and-so also had Ms. A. Gayan, who submitted that due to lapse on our part, the order dated, what is the date of the order?
order dated
Date of the order 12/4/2023.
2010, 23.
It could not be communicated to the respondent number 3.
My lord, on,
Was directed to appear personally before this court. As such, she seeks time to, she seeks posting of these matters again on 15/5/2023. So as to enable the respondent number 3 to personally appear before this court. In view of the request made by Ms. Gayan on personal grounds, the prayer stands allowed. Let this case be listed again on 15/5/2023. On which date the respondent number 3 shall positively remain present in person.
date to December.
Master.
Master.
Please, your lordship, my lord, the pleadings are complete in this matter. So subject to your lordship's convenience, if it can be taken up next week or week thereafter.
What is the matter?
It's regarding reservation seniority dispute based on reservation.
Why next week? Next year is, looks good. What is the urgency?
Urgency is that, my lord, the petitioner will be retiring in the month of September. So at least he can some days in the position. If ultimately he succeeds.
This has been admitted already.
No, notices were issued and it has been continuing like that.
You are appearing for it?
I am appearing for the respondent number 5.
And what about the other respondents?
Well, there is only
4 and 6 and 7.
the principal grievance is against respondent number 5 only. The others are not participating that way. Respondent number 5
No, but
in,
has notice been served on them?
yes, on 4570. WP 4570, my friend appears for respondent number 5. And he also represents the private respondent, the 6, na? In 5623, he represents respondent number 6.
There is another respondent, one Bhupen Hajarika. I don't know whether he has been served or not.
Notices served, but he has chosen not to participate.
Mr. S. Dutta, Senior Counsel, appearing for the petitioner in both these petitions submit that these matters are ready as regards service and feelings and therefore can be taken up for final disposal. Contending that his client is due for retirement in the month of September 2022. Mr. Dutta has sought expeditious disposal of the petition. Mr. I. Chaudhary, Senior Counsel, appearing for the respondent number 5 in item 42. As well as in item 42, you are for respondent number?
42, respondent number 6.
Item 42, respondent number 6 and 43, respondent number 5. Is present and submit that this matter be posted in the month of June. Mr. R. Dhar, standing counsel. And Mr. R. Dhar, standing counsel present and in view of the request made of the bar, register to verify whether this matter is ready at that service and issue the case for admission hearing as fixed. I please this case for admission hearing as fixed item on 15th of June 2023. 15th of June.
Okay.
In this matter, there is a violation of Honorable Court's order dated 27/2021 at page 35, Your Lordship. There's order at page 39, 38, 39 is the relevant portion. Lordship, page 38. Both the Commission Secretary Irrigation Department as well as Chief Engineer Irrigation are directed to do the needful as provided in the communication dated 1/10/2020 in the period of 1 month from the date of receipt certified copy.
Have been taken.
Here I appear for respondent number 3, my lord. The file has been moved to the my lord Advocate General for his opinion from the Finance Department. Can it be, my lord, after my lord 2 weeks, my lord, in the meantime?
Lordship, may I submit before my learned concludes, my lord? Lordship, here in this case, the petitioner has deprived the order of regularization came in the year 2005 itself. In his name, my lord, only because in between Chandra is there, a person with a similar name was given the benefit. Way back in 2005, I'll file a writ petition. There's the order from this honorable court dated 22/2/2019, my lord. I have annexed it and there were violations. Second time I have filed a writ petition, my lord. 2005, I have been deprived from the order of regularization, my lord, benefit of regularization.
And let it be after in that case 10 days, my lord. Let the opinion of the AG
If
court.
the petition is
Probably
supported,
maybe-
my lord.
AG will say High Court is wrong and set aside the order.
That I cannot say, my lord. But they are waiting for the,
This
Oh,
is
either
an
for-
internal matter. Opinion of AG is not a ground to
No, I'm not.
defer a contempt.
whatever is the present status, I am submitting it to the honorable court. Let me after 10 days. my lord.
If the order is not complied with, then what is the option we are left with? You are entitled to
Either-
take AG's opinion, etc. These are your internal matters.
My lord, I understand.
The
Yes, in the
institutional issue here is compliance with the court order.
Lordship,
You can either comply it or file an appeal.
that part, my lord.
Nobody can say
They are
that, no,
seeking
neither-
opinion on that part only. On that part only, they are seeking the opinion, my lord. Let it be after 10 days, my lord. It may not be 2 weeks, let it be 10.
There are two orders from this honorable court.
Yeah, you are a senior counsel, you know how it goes. They are
Lordship,
looking at it. They want to implement the court order.
I
Let's
pay
have it.
correspondence.
Lordship, but if I remember correctly, on the last occasion, Mr. H. appears, he submitted before this honorable court, positive instructions coming up from their end, your lordship. If I remember it correctly, your lordship. Now they're taking another step.
Senior counsel is by Ms. M. Counsel and counsel for the, from Petitioner. Mr. B. Ravi, standing counsel, finance has appeared for the respondent number 3 and submits in continuation of the stand of the department projected in order dated 10/4/2023 that the matter is under active consideration and therefore he be granted 10 days further time as last chance to obtain instruction. Mr. L. Upadhyay, Lanesh, counsel is present for respondent numbers 1 and 2.
2 and 4.
2 and 4. On the request of Mr. Gogoi, one final opportunity is given to him to seek instruction in the matter. It is made clear that on the next day, the court will consider what further orders are required to be passed in this life due to non-compliance of the court order. Register to release this matter again on 24th of May 2000.
And one more thing, my lord, the respondent fee is not the commissioner of finance department presently, but it's not.
That's why I'm not standing council final. Don't make these technical things, either comply with the court or file appeal. Nothing in between is going to work out. If you are happy or not happy, you are entitled to. Many orders you may not be. You have to file an appeal. Yes. Last question. Yes, item 45.
Yes, Your Lordship, in this matter, we have already received the affidavit in opposition filed by the respondents. So Your Lordship may kindly give us some few weeks' time, we'll file a reply.
How much time you want?
Lordship,
How much time you want?
2 weeks' time.
Miss,
Valentina Delabeno, Panyu.
council appearing to the petitioner submit that he has received a copy of the counter affidavit filed by the respond numbers.
Lordship,
Respond numbers. Counter affidavit filed by
and
the,
for the petition,
who has filed the counter affidavit?
3 and 4 years.
3 and 4.
Numbers 3 and 4. Therefore, the permitted to file 2 weeks time to obtain instruction file began. Mr. K. Kumar,
Yes, Your Lordship, I'm appealing for the official respondent, 1, 2, 3 and 4.
you are additional AG?
Yes,
K. Kumar, additional AG Assam is present on behalf of respond number 1, 2, 3 and 4. In view of the request made by the Commissioners Council, this matter stands adjourned for 3 weeks so as to enable her to file the agenda.
all right.
I'll be rising now. We'll sit again at 2 and continue some matters are there.
In this case, Lordship, I'm praying for an adjournment because Mr. R.K.D. Chaudhary, Lordship, he is in legs in court number 1 in an NIA matter, Lordship. It's a part of matter in going on since days, Lordship. In legs, Lordship. Senior counsel was informed, Your Lordship.
What is the difficulty? What is the idea about?
I think for minimum payment of wages, I just checked the record, Lordship.
Minimum?
Actually, he has been reinstated, but his due wages has not been paid. Last wages is been paid. An award was passed in our favor. They challenged that award. Now, during the pendency of this award, some of concerned workmen were reinstated.
Is he paying, is he getting his current wages?
Not current wages, last wages.
No, but now is he getting a wages? Is he receiving any money?
Getting the wages which he due at the time of his termination.
Is he getting any money?
Yes, 5,000 rupees per month.
5,000 rupees. What is this 5,000 rupees?
Lordship, I am handicapped, Lordship. I am just requested by the.
Well, that's all right, but he's working under whom?
Brahmaputra Board. Central government.
We'll fix a date.
Lordship.
Mr. A. Dasgupta, Learned Counsel for the Senior Counsel appearing for the applicant is present. However, Mr. D.J. Das, Learned Counsel appearing for the, CJC appearing for the respondents, fixed posting of this matter again on 23rd of May. The ground that the arguing counsel is unavailable today. Although there is urgency expressed in the matter, we have taken note of the prayer made by the Learned CJC. This matter is directed to be listed again on 23rd May 2023 as a fixed item.
Much obliged.
I'm appearing for the contempt number 1, my lord.
Yes.
So should be kindly this order, my lord.
What has happened? Order has been complied with.
Yes. Family pensionary benefit should be distributed amongst the two to find out. And the commissioner has done that, my lord. An inquiry was conducted and then it was found that. Lordship, see the second page. Last page, Lordship, kindly see, last page. In compliance of the order of the Honorable Guwahati High Court dated such a the undersigned takes a considerable decision that the family pension in respect of late Chandra Shutar, expired senior assistant under Shonitpur district, is to be shared equally between Kalpana Shutar, the first wife of Shutar, Chandra Shutar, and Srimati Nikita Shutar, the unmarried dependent daughter, by God. So it was divided between the two.
So order has been passed.
Operative part of the judgment, Lordship, may kindly page 15 of the petition. Operative part of the judgment.
Yes.
Page 15.
Yes,
Paragraph 11, my lord.
paragraph 11.
From 10, Lordship, we can see.
Now, after this division, are they receiving the money?
No, Lordship.
Now they have passed the order only recently, this order. It was passed on 18th of March 23. It was sent to the Director of Pension on 18th of March 23.
Who is appearing for director? of
That
pension?
is not a major party in this case, in the contempt petition. In the writ petition, director is a party, but contempt is not party.
Lordship, when we have filed this IA, at that time, the respondent number 1 has not appeared. So we have filed this IA to not to disperse the family pensioner benefits in the name of the respondent number 2. And as petitioner is also entitled for other retail benefits, and that should be given. And that shall also be divided to petitioner and respondent number 2. For that, we have filed this IA. Till that, respondent number 1 has not appeared. After that, it has appeared, so we have not served the copy to him.
But now, have you seen this order? They passed an order. Have you seen the order? They
Yes, Lordship, here it is mentioned about family pensionary benefits, but not about the other retail benefits. But being the legitimate child, she is also entitled for other retail benefits also.
What is other retirement benefit? What are the benefits?
Like gratuity, Lordship, PF and GPF.
These can't be decided in the contempt case.
Paragraph 10 says petitioner to the family pension on the benefits to the respondent number 6 and the daughter. So 2 of them have been minor. After
The order is only about family pension. Is it not?
Yes, Lordship.
Rule for 143. Pension rules.
Let my senior be heard also.
No, we'll close it today. If the director
No,
pension does not,
let my senior be heard.
no, we'll not allow it. The order has been passed, so they will comply with the court order. Now, if the director pension does not comply with the order, you move contempt proceeding against him, that's it. Other things are not covered by the judgment, by the order of the court. Had Ms. A. Bora Learned Counsel for the applicant, for the petitioner in the contempt case. Also have Mr. M. Nath Learned Senior Counsel assisted by Mr. A. Bhattacharjee appearing for the respond number 1. Respond number 1, Mr. A. Bora. M.R. Adhikari, Learned Counsel is present on behalf of the respond number 2. Mr. Nath has produced a copy of the order dated 7/2/2022 passed by the Commissioner, Panchayat and Rural Development Department, Assam. In compliance with the order dated 7/10/2020, distributing the pensionary benefit between the petitioner and the widow of the deceased employee, namely Srimati Kalpana Sutar, to submit that the order of this court has already been complied with. At this stage, Ms. Bora submits that the amount has neither been disbursed nor has the departmental authority dealt with the other post-retirement benefits of the father of the petitioner. Full stop. Insofar as non-compliance of the order is concerned, it appears that the matter is pending before the director of pension, but the petitioner has not yet demanded compliance of the order from the director of pension, nor is he a party in the present proceeding. Full stop. Coming to the other part of the submission of petitioner's counsel regarding the remaining part of the retirement benefit, it appears that no such relief has been granted. It appears from para 11 of the order dated 7/10/2020 that no such relief had been granted to the petitioner by the learned single judge. Therefore, the said aspect of the matter cannot be agitated in this contempt case. By granting leave to the petitioner to initiate appropriate proceeding as may be permissible under the law for redressal of our grievances, this contempt case stands closed. And in view of the order passed in the IS stands disposed.
Also, keep it as part of the records, my lord. I have got extra copy.
Report the book, copy of the order dated 7/3/2023, as well as the forwarding letter dated 18/3/2023, referring the matter to the Director of Pension, Assam, be retained in the record.
Okay.
May I please your lordship, my lord. Lord, in this petition, notice has been issued, my lord. But no affidavit has yet been filed, my lord.
Lordship, may I kindly see the age of the petition? Kindly pray. Now he's 24, my lord. At the time of advertisement, he is not the one of that, minimum of qualification, one of that age. But it should be 30 years.
This is advertisement for what?
For appointment of a Gaon.
Gaon, my lord.
Age is 30 years.
30 years, Lord.
My lord, the that advertisement, my lord, we put into challenge before this honorable court, my lord. Regarding that age criteria, that it was not rational to the earlier notification while it was 21 years, my lord. Then, my lord, this honorable court directed the commissioner and secretary to take a decision on our issue, my lord, and the commissioner and secretary, my lord, ultimately passed an order. My lord, may be pleased to find the at page 74, my lord. Annexure 17. That 35 years, my lord, had been decided to be read as 25 years. My lord. Now, my lord, that we are required to, my lord, for this notification, my lord, the age has been reduced to 25 years. Now, my lord, even then, as I am, my lord, not attained the 25 years. Earlier, it was 21 years of age, my lord. That's why, my lord, we put into challenge this notification again before my lordship, my lord, that this is not rational. And my lord, it was the, as earlier it was 21 years of age. And my lord, as the educational qualification is required only HSLC, my lord. So therefore, my lord, it should be in conformity with the earlier notification, my lord, of 21 years of age.
So what is the relief you are seeking here?
My lord, relief we are seeking, my lord, that this process of advertisement, I should be allowed to participate. And my lord, the selection of the respondent, my lord, which has been selected pursuant to the advertisement is also, my lord, not in conformity with
Don't
the.
you think your client
lord.
is a little too ambitious? First, set aside, and these are matters of policy.
That is,
National-
yes, my lord, that is my,
If the government policy is that 25 years, on what ground will set it, sir? What is the principle?
principle, my lord, government.
Can the
can-
court say, no, it should not be 25, it should be 21 or 13 or 15? How can the court say all these things?
My lord,
This is for the government to decide.
initially, my lord, court interferes, my lord. This honorable court in certain,
I am asking you, what is the principle? If the principle is not correct, I am not going to follow any order passed by the court.
my lord,
That is the mandate of a judge. What is to be followed is the ratio, the principle.
my lord,
Therefore, any order passed in any case will not be binding on this court. What
Right.
will be binding is the ratio. What is the ratio, you tell me? Only the principle of law declared or enunciated or propounded in a order, that will have a binding effect on a subsequent bench. Not any particular view taken. These are discretionary views taken by the judge. What is the principle which permits the writ court to interfere with a policy decision fixing the age limit to be 25 years? And the court has directed the matter to be re-examined. They have done it 25. So you will keep hammering on it till the age is brought below your client's age. As if the whole system is operating only to help your client get selected as Gaubra. Wait, when you attain 25, next year you will participate.
The minimum age is 30 years, Lordship, not the 25 years.
This 25 has again been raised to
No,
30.
Lordship, can see. My lord, that annexure 74, Lordship.
Annexure 74 or page
No, no,
74?
sorry, page 74, annexure 17, Lordship. It is the corresponding. Lordship में खाली page Lordship the 52, which was 30 verses. It is a mention Lordship. Amendment number 3, Lordship. Page 52, annexure 6. Yes, serial number 3, Lordship. In part, the may I read, Lordship. In the principal executive instruction, in the executive instruction number 162, in clause 1, subclause H, the first line of the figure, the word is 35. Actually, my lord, it should be 25. After that, my lord, it was, my lord, by way of the correspondence, it has been corrected. By way of correspondence, it has been corrected. My lord, it should be 25, because my lord, in the 19, after 18 lordship, that 19, there is my lord, that notification, the age was my lord 35 to reduce to 25. And thereafter, my lord, the 26, 11, 20, 21, my lord, when this notification come, my lord, they have my lord written age as 35. My lord.
So this 26(8) is latest.
This is 26 is the latest. My lord, it is the 30 years minimum.
And is it under challenge in this proceeding? 26(8)2021 is under challenge.
They are challenging my
Bhuya-
lord, that 74.
Mr. Bhuya, you seem to be silent, Mr. DSP.
My lord.
Have you challenged 26?
No, Lord,
2021? Huh?
No, my lord.
Then either I dismiss or you withdraw. What is the other option left? (26)(8) is the latest. It says 30 years.
My lord.
You have not challenged it.
No, my lord,
You want to participate in this election process. How is this permissible? Is it not sheer wastage of judicial time of the court? Huh? You also know no order will be passed in this case. Why are you then hanging on? I have a good submission to make on law or accept it.
my lord.
What do you want to do?
My lord, earlier when we challenged, my lord, that notification of 30 years, there is another writ petition filed by the petitioner, my lord, that was withdrawn. My lord, it is under challenge, my lord, in prayer number 2, my lord. 26 prayer number 2, my lord, may kindly 26. (26)8, 2021.
So why is it unconstitutional?
Lord, for that, my lord, may I pray for a short adjournment, my lord? To satisfy my lord, if I can, my lord, if I can, my lord.
Because of this order, my lord, I have been selected, not appointed.
Next
Others have
Tuesday,
been appointed, my lord.
next Tuesday, my lord,
Because of this writ petition, my lord, my appointment is withholding, my lord.
there is an,
No, Mr. There
And-
is nothing in this matter.
And
Unnecessary. All right, heard Mr. R. Bhuya, learned counsel appearing for the writ petitioner, also heard Mr. J. Hamlet Leonard. I am disposing of the matter, dismissing it.
Tuesday, my lord. I can,
2000,
If you can't make out a case, there will be cost of
My lord.
10,000. Judicial time matters now. Everybody
can-
thinks judges are not working.
I can understand, my lord.
That we will not accept anymore. I'll put it on Tuesday, but if you don't succeed, 10,000 rupees cost.
That is, my lord.
Yes, we are now getting into tough zone.
No, my lord, my lord, I as a officer of the court, my lord, I am also bearing some responsibility, my lord. I should not waste.
If you don't have a case,
Well,
then what?
my
Why did you not come prepared today?
my lord, actually, I have met with a small accident, my lord. I cannot.
my lord, even
That's
my
why,
lord, age 25 was not challenged. Page 49, by notification, my lord, 19/7/2019, my lord, it was reduced to 25, from 35 to
We'll have it
25.
day after tomorrow on the
Lord.
request of Mr. Bhuya, learned counsel for the petitioner. Is to release the matter again day after tomorrow as a fixed item. Mr. So and so are present for this.
Oblige me.
So casual approach everybody has, like if the matter is taken up, then I'll ask for an adjournment. If the
That's
court
all.
allows, then fine. If the court has questions to ask,
My,
then I'll seek for. As if we are sitting here to only gather matters. Everybody wants a date, nobody comes prepared.
take apology for that.
It's coming.
My,
Just wait for another 2 weeks. It's coming. We will have this, these are all recorded and this will go now. If you don't come prepared, your matter is over.
Obliged, my lord. May I please, my lord, may we please to, my lord, peruse the order dated 15/3/23, my lord, when my lord had issued notice in the matter. 15/3/23, my lord.
Yes.
My lord, on the basis of my submissions with regard to the manner in which the inquiry was conducted, my lord was pleased to direct the respondent number 4 to produce the records. The orders have been served, my lord. There is a Lavjima note of 3/5.
Orders or notice?
A notice, sorry, my lord. The notice with the order of my lord have been served on them. And they were supposed to, my lord, produce the records today.
Who is for the respondent number 4?
Your Lordship, I'm here on behalf of my senior Miss M. Bhattacharjee, who is on legs in another court. We have filed a wakalatnama on behalf of respondent number 4 yesterday, Your Lordship. And we seek some time to to take the appropriate instructions in this matter.
No, the instruction is there in the order itself.
No, from my senior in this matter, who is actually in another court. We have filed the wakalatnama on yesterday on behalf of respondent number 4, the Borpeta Road.
Municipal court.
We'll have it on 24th.
24th, my lord, lordship. And my lord, let them have that because that will settle the issue.
Mr. Yukena, senior counsel has appeared for the petitioner. Ms. S. Burwal and government advocate Assam is present for respondent numbers 1, 2, and 3. Miss
P. Dasgupta, Your
P.
Lordship.
Dasgupta and Miss M. Bhattacharjee, learned counsel, have appeared on behalf of the respondent number 4 only yesterday by filing wakalatnama. Ms. Dasgupta seeks 10 days time to obtain instruction in the matter and address this court. Prayer allowed. The registry to list this matter again on 24/5/2023 as fixed item. On the next date fixed, the counsel for the respondent number 4 to produce the records and file affidavit in the meantime, issue advice. This matter will be taken up for an attempt will be made to dispose of this matter at the stage of admission hearing.
Much obliged.
Much obliged, Your Lordship.
Lordship, the details, Lordship, the details instruction as well as the scan copy of the records is received, Lordship. That's
What is the matter about?
Lordship, the matter relates to suspension, Lordship. I am a MMR, Muslim marriage registrar, Lordship. I was placed under suspension by the respondent authority way back on July 4th, 2022, Lordship. 11 months running, Lordship, I am under suspension, Lordship. No show cause notice was issued before suspension.
So what is your instruction?
Lordship, in the several time, Lordship, the authority would like to serve upon the notice, Lordship, but he defer to receive the notice, Lordship.
No, you are proceeding against him.
Lordship.
He is a MMR. This proceeding is under which provision of law?
No provision of lordship. There
I am
is,
not asking you. I
But-
will adjourn the matter for 6 weeks. Don't interfere. Please take your seat. Under which provision of law are you proceeding against him? Mr. Goswami,
Lordship.
what is asking you?
Lordship, Lordship, the MMR, Lordship, is not cadre of the state government, Lordship. The only he is the registered MMR, Lordship, which was given to the Lordship.
So that's what I'm asking. Which,
Yes.
under which provision of law he has been suspended?
Lordship, Lordship suspect.
If you can't answer, I'll set aside the order right now. So whatever you have to say, you have 5 minutes.
Procedure.
There is a very detailed order passed by the court. You must have seen it.
Lordship, regarding the procedure, Lordship,
Hmm.
regarding the procedure, in what procedure is
Which provision of law?
Lordship, that is difficult to say at this moment, Lordship.
Then you say it in the appellate stage.
Lordship,
Now we'll finish it.
Lordship, I'll fix the matter, 2 days,
No,
Lordship.
no, no.
After 2 days, Lordship.
In every question is being taken for granted.
But law is not specifically given in my instruction,
Then
Lordship.
if you don't have the power, you can't do it. As simple as that.
Lordship. But it is, Lordship.
Assam Muslim marriage.
lordship, as per rule 5, rule 12D, lordship, and the rule 35, the Assam Muslim Marriage and Divorce Register Rules, lordship, 1935.
Hmm.
I forgot to book, bring the book, my lord, that is the provision. My lord, MMR, my lord, that he can be removed or he can be suspended, my lord, that's a rule.
By whom? By whom?
By the my lord, district register.
Where is this? Where is the
That is, my lord, that one instruction I have received, my lord, that regarding the rule laws.
I'm having the book.
Go through it and see. Heard Mr. So-and-so for the petitioner, also heard Mr. J. Henry, Land Standing Council, Revenue Department, Assam, and Mr. J.K. Goswami, Leonard, Additional Senior Government Advocate, who have produced the recent instruction dated 19/4/2023 to submit that the action taken against the petitioner is in terms of the provisions of which act?
Well, Assam Muslim Marriage and Divorce Registration Rule, lordship.
The Assam Muslim Marriage Registration and Divorce Act, rules of 2000
35, lordship. 1935.
or 1935. However, the Learned Department Council had played for some time to argue on the law from Mr. So-and-so appearing to the petitioner also plays for some time to examine the written instruction, since the respondents have not filed an affidavit. In view of the prayer made at the bar, this petition is directed to be listed again on 19th of May 2023 as a fifth item. 19th May will take up for disposal.
Lordship.
You see, when a matter is listed,
Lordship.
it will be taken up for disposal.
I'm sorry, lordship.
This time that the councils understand this. These things are not that, oh, if you hear it, then put it on another day. Every case is listed for passing an effective order. If the judge is willing to pass, the assistance is not coming. Neither party is prepared. You have to anticipate the questions and answer the. All right.
Obliged, I am obliged.
Yes. List is over. And what, there is no hearing list here. Anybody is there? Why? Party was 9. Huh? Not a single council is present at 2:40, 2:35 to do party hearing matters. So almost half day court's time, judicial time is left. So what is happening? I don't understand why. No hearing on Wednesday and Friday. Please send a mail or circular. Hearing matters will be taken.